court's responsibility to properly capture and reflect the views of our constituents. Second, we're members of a political party who were likewise elected to formulate policies for our nation. For the Workers' Party, our mandate as loyal opposition is to provide alternative views and constructive critique of the ruling party's ideas and proposals. And third, we are, of course, individuals who carry our own beliefs and convictions. Rarely is there confluence in these three identities, which results in us having to make a reasonable effort at balancing between different preferences and exercising compromise. But this is not necessarily as difficult as it sounds. For esoteric bills, our electorate often expects us to do our homework and choose what is in the best interest of the country at large. Hence, they may not hew to strongly held views of their own. At other times, there are bipartisan consensus on how best to proceed. And so our interventions in Parliament are limited to flagging points of concern, but the Workers' Party nevertheless votes alongside the ruling party. In a matter such as the repeal of Section 377A and the attendant proposed constitutional amendments, however, it will appear that it's not only an intractable divide between the different interests that we represent, but our own personal convictions may play a role in the choices that we are forced to make. In my speech, I wish to explain why I believe that these disparate views can be reconciled and how this leads me to vote the way that I will. In the many letters written to me by the residents of Sengkang, those that have expressed their concern over the repeal of 377A have almost uniformly cited their reservation over how such a repeal would open the floodgates to revisions to the traditionalist interpretation of marriage. This concern has not only been limited to those who are more religiously inclined. I've spoken to residents who would otherwise hold no strong views on 377A, nevertheless underscore their wish that the heterosexual definition of marriage be somehow protected. To be clear, this is a prospective fear, one based on how the repeal of 377A is a slippery slope. Once the law is removed, the floodgates are open and all manner of permissive laws become possible. In contrast, 377A is currently on the books, and its consenting relations between two men is currently a crime. This is no longer prospective, but real. In principle, a man engaged in same-sex sexual relations could be jailed if the strict letter of the law were to be followed. The repeal decision is thus a trade-off between the removal of a tangible, actual threat of imprisonment versus a perceived potential concern over how repeal could undermine marriage. It seems clear to me that there is not and cannot be a genuine equivalence between the two. Now, the usual pushback behind claims that 377A constitutes an actual violation of the law is that 377A is not enforced, and on the basis of court judgments, will not be unless otherwise instructed by the Attorney General. This suggests that the article is merely a relic, one that has no bite, and hence any fear is similarly ephemeral. Why not the existing status quo then? It is true that the courts have previously ruled that 377A would not be prosecuted, and even so, sexual relations between men remains on the books an arrestable offense. Think about what this means when the status of law, of the rule of law in our country, if we insist on instituting laws that simultaneously do not matter in practice. How many more de jure issues also would not matter de facto? If we wish to make a slippery slope argument, this strikes me as a far slipperier one. Furthermore, we should recognize that even an unenforced law can have effects on individuals and society. Think of the symbolism behind what a law, or any law, implies. Suppose for a moment that there was a law prohibiting relationships between individuals of different races. And further suppose that a similar legal precedent and political compromise exists, in that those who are in such a miscegenated relationship are assured that they will never be prosecuted it is a hypothetical, but is it fair to expect those who are in a mixed-race relationship to accept the assurance that such a sword of Damocles hanging over their relationship doesn't really mean anything? To take the argument further, should we expect that individuals will feel that they are a fair and equal part of society when society has deigned it permissible to have a law that, even while unenforced, nevertheless explicitly condemns their behavior? Can we expect such individuals to truly feel that they're accepted as a part of Singaporean society when Singaporean law declares them to be criminals? Some would suggest that Singapore is different. We are an Eastern society with different cultural mores and practices. They argue that 3778 amounts to bringing in, a repeal of 3778 amounts to bringing in the polarization and cultural wars so prevalent in the seemingly dysfunctional democracies of the West, back home. I agree that Singapore is different. Our cultural norms skew toward greater social conservatism, and society stresses compromise for the sake of harmony, rather than the contentious and often raucous activism favored by civil society and activism in the West. But an untenable status quo, however entrenched, does not imply that all is well under the surface. For those who keenly feel the yoke of discrimination, suggesting that we should keep things the way that they've always been, simply because that's how it's always been, is more than simply benign neglect. It is an insult to the plight, to the burden that they had been bearing, perhaps silently until now. It's like telling a prisoner that their desire for freedom is an attempt to stir up unrest while they're in jail. As a man attracted to the opposite sex, I can never fully empathize what it means to develop feelings for someone of the same gender. But when I was a hot-blooded teenager, I had a dear friend who turned out to be gay, explained to me what his world was like. The analogy has stayed with me ever since. Just imagine, he said, if the way you feel about women, the strong, unrelenting attraction that you've when you first meet, the wish to share one's most innermost thoughts and feelings with them, the deep desire to be with the person for the rest of your life. Imagine if all that was not the natural order of things. Imagine that society deemed my attraction to women as not just aberrant, but also judged intimate expressions of my love to be criminal. This isn't too far from other historical legacies where the law deemed certain forms of love to be illegal. As recently as the 1960s, interracial relationships were limited in some form in as many as 31 US states, as it was in Nazi Germany and apartheid South Africa. But I'm not equating the two. My point is that my own relationship, as well as that of my parents, which occurred between different ethnicities, would have fallen afoul of the law. The usual retort to such scenarios is that it's contrived. Humans are not animals, and after all, we can always exercise self-restraint. Some argue that because same-sex attraction is ultimately psychological, it can be overturned with intervention and counseling. Perhaps. I'm not here to question the natural biological order, which I respect. After all, it is a physiological reality that asexual reproduction among mammals is impossible, and hence the male-female pairing is necessary to ensure the continuation of these species. Even so, for certain individuals, such attractions are deeply embedded in what may be regarded as innate, biologically led behavior. For these reasons, I support the repeal of the discriminatory law that is 377A. Even so, I also cannot ignore how many in our Asian society continue to equate marriage and partnership to one between a man and a woman. This view is held not only by those who are religious, by which I mean not just groups that have been more vocal about traditional marriage, such as evangelical Christians and Muslims, but based on my conversations with residents in Sengkang and beyond, also those who do not strongly profess any faith. For these Singaporeans, the fact that marriage must involve a union between a man and a woman goes beyond a legally binding contractual relationship. It is a fundamental belief, a worldview. This sense is so deeply ingrained that they are not only unable to accept the principle of same-sex marriage. For them, were such marriages to become recognized, they, perhaps paradoxically, would feel that society is no longer representative of who they are. But some may even go as far as to feel that it has turned against them. It is secondary that heterosexual norms remain the firm majority. Many will feel a sense of exclusion and victimhood. So it turns out this worldview is remarkably pervasive. While I do not have comprehensive data, I have had many conversations over the course of the past few months. And I would be willing to venture that a significant majority of Singaporeans, including those in Sengkang, including otherwise liberal-minded spirits, and even including those who are otherwise sympathetic about the repeal of 377A, carry this perspective close to their hearts. It is important that we do not dismiss this worldview as emanating from an oppressive majority, finally receiving their comeuppance. This is because I actually believe that such sentiments, even if some may argue are seemingly misplaced, are indeed genuine. When I was a teenager, I took my Christian faith very seriously, to a point where I even harbored ambitions to be a missionary. While I'm no longer as zealous today as I was, I can fully empathize with how it's like to hold fast to a set of tenets and beliefs that so completely shape one's worldview that it would be wholly inconceivable to not expect that challenges to it would not be met with visceral resistance. To reiterate, this is not a sentiment that is limited to those that are religious. It is one that is accepted by broad segments of Singaporean society, almost to a point where it's regarded as self-evident among these groups. And to those within this group, their sense of identity and meaning have as much tied to heteronormativity as those who identify as homosexual tie theirs otherwise. Just as important, threats to these identities affect their behaviors and their welfare. It is for this reason that I do not see a decision to alter the Constitution as essentially a compromise for merely the sake of political expediency, necessary for the repeal of 377A. Rather, it is the manner by which the state will echo what society as a whole believes in. Prime Minister Lee had explained in his National Day speech that challenges via the judicial system were becoming more insistent and that we do not wish to go down the dangerous road of judicial activism. He also explained why decisions on the repeal of 377A and perhaps more importantly, constitutional amendments should be determined in the legislature. He was articulating, in this specific instance, the principle of de facto parliamentary sovereignty, a notion that others have observed also applies to Singapore. As Workers' Party Chair Sylvia Lim has articulated, there may be potential legal lacunae that passing such a constitutional amendment may entail. I'm also aware that the amendment will continue to discriminate, albeit to a lesser extent, against those who wish to normalize their same-sex relationship, especially in matters of public policy. This question of jurisprudence, where I am very sympathetic to the views of Ms. Lim, is important and a concern. But even accepting this argument, I believe that there remains a strong justification for ensuring that deliberation of matters of broad societal concern occur within the forum designed for such matters, which is this House. I will also explain why I believe that a social institution such as marriage may reasonably be included in a foundational document such as the Constitution. Keeping in mind that representative democracy will always be imperfect, it is nevertheless the closest system we have that reasonably aggregates our preferences of our people at large. And in our time, the significant majority of Singaporeans have articulated their preference for clear reassurance that the institution of marriage be protected. Could this justify a constitutional amendment then? From my perspective, I do not see why not. Constitutions are live documents, meant, as Thomas Jefferson once said, to serve the present generation. They embody the rights of nature, of society, and of government. These are essential principles of constitutional design. Many constitutions embed rights of association. Consequently, I believe that it is reasonable that our Singaporean constitution captures the key institutions that our society cherishes, which includes this cornerstone institution of marriage. Mr. Speaker, as members of Parliament, I believe that it's paramount that we carry out our duties of representation faithfully, echoing to the best of our ability the views of the majority of our constituents, even when this position may differ from what we individually may hold. It is in this light that I see a vote in favor of a constitutional amendment that codifies the institution of marriage as a reflection of the conversations I've had with my many diverse constituents on this matter. Keen observers will nevertheless note that constitutional amendments that were proposed, however, merely refer to how the legislature may define marriage, leaving the specific definition indeterminate. Should the amendments be more specific then? This is where I depart from those who would go further, those who are asking for a heterosexual definition of marriage to be hard-coded into the Constitution. In contrast to the more fundamental notion of the institution of marriage, its definition does not strike me as an unwavering principle that belongs to a constitution. It is therefore appropriate that such a definition be clarified only in subsidiary legislation, subject to change by the people of the contemporary time. Almost 2 centuries ago, the French political philosopher Alexis de Tocqueville documented his observations on the then nascent state of democracy in the United States. He shared his admiration for the democratic project as it unfolded in America. Even so, he pointed to an inherent tension in the power of democratic majority opinion. And in particular, he highlighted what he observed to be, quote, the tyranny of the majority, unquote. Tocqueville did not much propose a resolution to this conundrum beyond suggesting, like his contemporary English philosopher John Stuart Mill, that appropriate respect for individualism and liberty could offer a way out of this conundrum. Importantly, these thinkers believed that it was vital for each society to arrive at their own definition of the limits that public opinion would have over individual lives. One could argue that democratic republics, of which Singapore is one, are practical manifestations of this compromise between individual rights and popular opinion. We stand today at a similar precipice, albeit in our own little red dot. The way I see it, the repeal of 377A is the way that our society respects these individual rights, while enshrining the institution of marriage within the Constitution is how we respect the values of the majority. Hence, the decision we make today is not solely about a political compromise, as so many have suggested. It's also about striking the balance between the principles of individualism and majoritarianism. As a republic, we are required to do right by our people. We have it right there in our pledge, a commitment to justice and equality, which is why fundamentally discriminatory laws such as 377A should no longer be allowed to stand. But at the same time, our commitment to, also in our pledge, build a democratic society calls on us to affirm our common values, such as marriage, that make us one united people. That is why I will vote yes to both of these amendments today.
Ms. Herting-Rue.
Mr. Speaker, like many of us in this House, I'm often filled with questions about the type of world we live in, the world that I want my children to inherit from us. I worry about how I can inculcate in them the right values, the right tools to be able to dissect tricky situations and to be able to tell right from wrong, even when the world around you sometimes appears to have gone mad. Today, my sons are still young, and it will be years yet before they are old enough to understand the topics we are debating and to have their own views on these matters, which touch on the very core of what it means to be humans living together in a society. But I hope that when they are old enough, they will be able to understand and appreciate what I say here today, as it is my contribution to what I hope will be a healthy and positive debate for a more tolerant and accepting nation. These are topics that are fundamental to who we are as individuals, who we are as a society. And because society is a collection of individuals, this necessarily means that we are people who have different views and ways of looking at things. It comes as no surprise that we have many different viewpoints, and that some amongst us do feel extremely passionately about the issues involved. This is a good thing in and of itself, as it shows that we care deeply about the society we live in. When the repeal of Section 377A and the amendments to the Constitution were first announced, my thoughts were initially clear-cut. This relates to my conscience, and it seems straightforward. Yet, as I listened to friends and residents who shared their thoughts with me on the matter, I realized that there was a wide variety of opinion on the matter, each informed by one's own life experiences, their own social or religious value systems. It would also be impossible to find a position that everyone fully agreed on. But whether they are for or against repeal, one thing was clear to me, that everyone is motivated by the same desire to see Singapore move in the right direction, in the direction of the greater good. I think it is crucial that we do not lose sight of this, even as we may debate over what the greater good is. This is important because having many different cultures, values, or viewpoints is not new to Singapore, and it will not be the last time we face an issue that risks our society becoming increasingly polarized. But I am reminded that we can face challenges as a nation and can do so soberly in a way that balances the individual's right to hold their own beliefs and practices with the need to build a cohesive society founded on principles of understanding and acceptance. It is also not lost on me that I am speaking today not just as an individual, but as a representative of my constituents who have entrusted this privilege to me and my teammates. This is something that we will never take for granted, even as we strive each day to be worthy of that trust. But Sengkang, like Singapore, is multifaceted. And as interests and viewpoints are split on 377A, I believe we need to remind ourselves of the same principles of acceptance and understanding that have helped us build a strong ship that can weather difficult storms. I believe that we must have empathy and put ourselves in the shoes of those who hold different views from us, and to try our very best to understand where the concerns are coming from. We must approach this difference with respect. It does not do anyone favors to dismiss the other as being hysterical, overblown, or wanting to impose corrupt values on others. We must, above all, work to not discriminate against our fellow citizens. It is this principle that moves me to vote in support of repeal today. I do not believe that we should have a law in the books that is plainly and obviously discriminatory. It sends a signal that one segment of society is so morally reprehensible that their identity should be considered criminal, even if it is only on paper. It excuses discriminatory behavior and contradicts the pledge we take as citizens of Singapore to build a democratic society based on justice and equality. Not repealing Section 377A today would be at odds with steps that Singapore is taking to be a fairer and more equitable society for all, and will go against the principles behind the government's welcome announcement that we will finally legislate against discrimination. Many in this House have already mentioned the government's announcement to introduce anti-discrimination legislation, and I believe that the repeal of 377A plays its part in our move towards a more inclusive society. Some residents and concerned citizens have written to me to express concerns about the repeal of Section 377A and the deleterious effect that this will have on the next generation. Having 3 young and curious children myself, I fully appreciate where this is coming from. And indeed, I often find myself worrying about how to teach them to know right from wrong and to be able to distinguish between good and bad influences. After all, we cannot completely insulate them from the outside world and our children will be exposed to many different ideas and arguments which we believe are wrong. Our role as a parent is to educate, to guide them as we think fit, and to have a sense of moral values which they can then apply to different situations. Yet, our children are also their own people, and we must accept that they too will eventually grow up to have their own views, make their own choices, and to deal with the consequences of their actions. And while it is true that a country's laws do provide some moral guardrails for what is acceptable to society as a whole, history has shown us that in some instances, this has not always been the case. After all, I like to think that if I lived in a time and society where slavery was legal and accepted, I would still teach my children that the very concept of a human owning another human is abhorrent and unacceptable under any circumstances. Having said all of this, I have also heard and understand the concerns of those who feel that the repeal of Section 377A will be a slippery slope to further shifts in policy that they feel are simply unacceptable, or that its repeal would cause deep faults and divisions in society that are irreparable. I understand and respect their concern, but since as early as 2007, the regard for Section 377A as a bad law has been growing. Legal personages, including former judges of the Court of Appeal and a former Chief Justice, have cast doubt on its constitutionality. Similar arguments have been made in this House before as well. If not today, the law would likely have been struck down in the near term. But we must also not mix legality with morality. The repeal rejects a legal framework of discrimination, but parents remain able to educate our children and impart the moral lessons that we want within our household, shaped by our own beliefs and faiths. The concerns relating to the silencing of certain groups are also, I believe, understandable. However, Article 15 of our Constitution guarantees the freedom of religion in Singapore, specifying that every person has the right to profess and practice his religion and to propagate it. This right has been upheld by the Court of Appeal. And if there should be any proposed amendments to remove or water down the right to religious freedom in Singapore, I will not hesitate to oppose it. In fact, this approach is similar to thorny moral questions that are handled differently between religions or communities today, yet our laws are secular and don't attempt to enshrine the moral compass of each group. Our laws seek instead to provide the protection for each community from discriminatory treatment from another. The same principle applies here, and the protection of religious freedom will remain a core tenet of our democracy. With this in mind, I record my concern about the proposed constitutional amendment before us. I appreciate the concern behind its formation, yet from a legal perspective, the proposed amendments carve out an area of legislative decision-making and functionally shields it from judicial review. Specifically, the proposed Articles 156, 3B and 4 prevent laws and policies relating to the heterosexual definition of marriage from being challenged in the court on the basis of the fundamental liberties provisions in the Constitution. This causes me some concern. While I can understand and appreciate that the majority of Singaporeans feel that marriage is between a man and woman and share the concern about a judiciary running roughshod over the will of the people as expressed through Parliament, I note that the Singapore courts have always been conscious of the concept of parliamentary sovereignty, giving precedence to the lawmaking function of Parliament, and are ever cognizant of not overstepping the line into judicial lawmaking. Perhaps in taking fright at the phantom menace of judicial activism, we may be losing sight of a more fundamental principle, that the judiciary should be the ultimate arbiter of the constitutionality of legislation and has an important role in safeguarding the fundamental liberties protected therein. Article 156, while not an ouster clause in the traditional sense, functionally shields legislation from being tested against the protection of fundamental liberties under Part 4 of the Constitution. This concern goes beyond the present issue, and I hope we will not lose sight of the bigger picture. If we were to pass the constitutional amendment today that prevents the courts from determining the constitutionality of a legislative policy, What would stop a future parliament from passing discriminatory legislation and then shielding it from judicial oversight? For example, a future parliament may decide to pass or entrench laws that prevent the propagation of one's religion and then immunize that from court challenge on the basis of the constitutional protection for religious expression by introducing a carve-out similar to the present amendment as contained in Articles 1563 and 4. I would additionally urge empathy when debating and passing the constitutional amendment. While I applaud removing the divisive thorn of Section 377A from the body politic, I worry too that the constitutional amendment may continue to advance the divisiveness that we precisely want to combat. Although I understand and appreciate why the government has introduced a new Article 156, I find that I must abstain from the amendments proposed to the Constitution due to my concerns relating to the carve-out from judicial oversight. Finally, the divergent views on Section 377A underscore the need for measured dialogue, for opportunities to walk in the shoes of another, to not view fellow Singaporeans as an existential threat, and to not underestimate the good sense, resilience, and pragmatism of the Singaporean people. For a pluralistic society like Singapore, it is in walking together, in conversation with each other, all the while cognizant and respectful of our differences, that we are able to move forward. Sometimes, legislation is not just an imperfect substitution for society's greater good, it can be a barrier to it. I note that I have spoken very much in the abstract so far on principles and ideas. Yet, allow me the liberty to close with a personal anecdote about a boy I grew up with in this part of the world. We moved to different cities in our teens and did not see each other for almost a decade. One day, in our 20s, our paths were fortuitous enough to cross again, thousands of miles from home. And I remember sitting up late one night, chatting about nothing in particular. I made a throwaway, teasing comment about whether he would take girls to a particular spot to impress them. What followed next was totally unexpected. He suddenly grew quiet and paused for a long while, looking away. I could see that his mind was racing, and he swallowed hard a few times. Finally, he looked at me and said, "You probably don't know this, but I'm gay." I thought a long time about whether to tell you, but decided to do so because I think you'd be okay with it. It was now my turn to be silenced, as he started telling me about how a few months ago he attended his sister's wedding, where he felt compelled to tell lie upon lie to well-meaning relatives, asking when would it be his turn to get married. He felt like a total charlatan, but overriding this was his greatest fear, that he did not want to bring shame upon his parents. I will never forget the fear and anguish and the pain in his eyes, and the regret that this was not the first nor the last time I saw these emotions as someone came out to me about their sexual orientation, all because they feared condemnation and disgust for who they were. It is a whirlwind of emotions that I will never fully understand, and I would not wish this on anyone. It is a timely reminder that for the vast majority of us, the topics we discuss today are but academic to our own personal situation. Yet to some of our fellow Singaporeans, every moment of their lives are affected by it. We do not have to condone it, nor encourage it, but I hope we can find it within ourselves to try to empathize with them, even just a little bit. That we can find it within ourselves to be able to live and hope and pray that LGBTI members of our community are able to live without discrimination and fear of being ostracized. Conversely, those who support the repeal of 377A, or even feel that we should go further, should also not attempt to bludgeon their views upon those who are deeply uncomfortable with it, and instead try to understand the reasons behind why they feel this way. This will be a start towards better understanding each other and how we can begin to heal any rifts that may have arisen. After Section 377A is repealed, life will go on. Families and spouses who love and value each other and their children will continue to do so. Love and hope can still triumph over anger and mistrust, and we will still open our doors and hearts to our neighbors in the community who need an extra helping hand, like the countless stories of neighborhood group chats stepping in during the pandemic, the students of our Sengkang schools who came together to make gift cards to show their appreciation for our healthcare heroes in our healthcare facilities and their vaccination centers. This is what makes us a nation, as one nation, and I hope we never lose sight of this nor stop fighting to keep this as our shared future. Thank you.
Dr. Tanya Song.
Mr. Speaker, in my view, the proposed amendments are nothing more than stating the current social norms. I am not a lawyer. Let the lawyers discuss the legal aspects of the implications of such a change. I am not a religious leader. I look to them to lead the future discussions of what their faith finds permissible. I speak to you now as a doctor and as a mother of boys. As a doctor, I will treat all patients who come before me equally, regardless of race, language, or religion, and I add sexual preferences or gender identity. I ask about these only to advise on any impact on their medical care. As a mother of young boys, I want for them a world where they can grow safely in. What does that mean? Think back to your own growing years. It was a time to find yourself, your identity, and who you are. And I dare say that there are some adults who are still searching or may never find the answer their whole lives. We form our identity through multiple factors. Our character at birth, be it extro or introverted, then shaped by family, school, and peers. Teenagers explore their sexuality and their gender identity. In my time, tomboyish girls and effeminate boys were given mocking and even derogatory names. For those of us who are lucky to never be confused as to whether you like a boy or girl, it was already not easy. We still worry and fuss over whether your crush like you back, collect red saga seeds, four hearts from bus tickets, and listen to heartbreak songs. For those who felt an attraction to someone of the same gender, I can only imagine the fear and anxiety. Fear that there's something wrong with you, that your parents will disown you, that your friends will call you a freak. How many have suppressed their feelings and stayed single or went on to have a hetero relationship just to fit in? And how many are deeply unhappy? For those who have advocated actively for LGBTQ rights, I applaud their steadfast commitment and bravery. I am glad that one key change will be achieved, the decriminalization of the homosexual male. I look to an environment where each person can grow and explore safely. As I've said in most of my other speeches, education is key. Education by the family, by formal schooling, and by the various faiths. For those people facing conflicts and stress, there must be safe havens for them to seek fair and balanced counseling without undue influence. Perhaps the healthcare profession needs to step up and lead this with pediatricians, psychiatrists, psychologists who are trained and experienced, professional providers who do not impose their personal views. In the school, I urge the Ministry of Education to review the sex education component to ensure that it is based on science and facts, while controversial opinions and trends are clearly stated as such. This will be a guide for parents to use in our own conversations at home with our growing children. To fellow parents, if you, like me, grew up without any knowledge of LGBT terms, let us educate ourselves. What is hetero, homo, pan, or asexual? What is trans or cisgender? What is a sexual orientation versus gender identity? Only then are we equipped to guide our children as they grow and explore. This is when we can meaningfully share our personal beliefs, our religious convictions, and allow the child to find his or her own way with love and support. We fear what we don't know. We react with anger when we are hurt. We are all talking a lot, but are we listening? I am deeply aware of how divisive discussing LGBT rights is and how society may become fragmented We are one Singapore, one united people. I urge everyone to stay calm and be kind. The above notwithstanding, I support both amendments.
Mr. Seah, your turn.
Mr. Speaker, sir, before I speak on the substantive matters concerning the Constitution Amendment and the repeal of Section 377A, let me first make one point that I think has not been made enough. And this is the fact that the debate that we are having here yesterday and today in this House is a milestone, a huge milestone for our evolving democracy. It reflects the political leadership of a government and a parliamentary majority who have resolved to rise to our duty, not abdicate from our responsibilities, and find the political courage and gumption to confront the difficult issues head-on. Do what is right, even if there is no political favor to be gained, and indeed, every chance of a political cost to bear. Once the prospects of the courts striking down Section 377A in a future challenge became clear, this government of the day did not choose to unsee what it had seen. The government did not look the other way. Instead, we sprang into action, put it squarely on the agenda as our duty required us to, and set out to find a way forward for all Singaporeans, difficult as it may be. And so I say, especially to the youths who desire a more robust democracy in Singapore, I say, let's celebrate this moment. Let's celebrate this moment. This is our democracy in action. This is our democracy growing stronger. I listened to my colleagues yesterday, Mr. Chris D'Souza, Mr. Alex Yam, Minister Vivian Balakrishnan, Ms. Jessica Tan, for example, who hold very strong beliefs on the family unit and want the institution of marriage to be protected and strengthened. Nonetheless, eventually, by the end of their speeches, they have also expressed their strong support for repeal in this debate. And then, on the other hand, there was SPS Bayam Keng, for example, who has been advocating strongly for repeal, indeed, since 2007. And yet, in this debate, eventually, by the end of the speech, he has also expressed strong support for protecting the institution of marriage. So, very different starting points. Repeal on the one hand, protecting the institution of marriage on the other, and a broad tent of views, a broad tent of starting points, even amongst PAP MPs, representing various parts of our society. Yet, we have found mutual accommodation. We have found convergence in support of both bills. And we have closed ranks and come together to try and bring all Singaporeans along on the way forward, together in the national interest, our personal views notwithstanding, as my colleague, Mr. Murali Pillay, has so eloquently put it. This is how a responsible governing party works. This is our democracy in action. And I am glad that opposition members and nominated members have all joined us in seizing this moment. We owe it to Singaporeans to do right by our democracy. We discuss the difficult issues directly, and above all, we stand for unity and compassion as one people. Mr. Speaker, sir, now let me get to the substantive matters. First, on the repeal of Section 377A. I'll start with a quick story. I once asked two friends, husband and wife in their 30s, young parents to two kids, and we were talking about their expectations of their children. And I asked them, what if their son turns out to be gay and wishes to bring his partner home to meet them? What would they think? Without missing a beat, they replied me, they cannot even begin to contemplate and imagine such a scenario. Now, I don't think they belong to a minority of young parents today. Far from it. Yet, if their son does turn out to be gay, I would make a guess that they will, one, love him all the same, and two, they will certainly not want their son and his acts of intimacy with his partner, consensual in private, to be labeled as criminal. Why should their son be labeled a criminal? This, I think, is the crux of the Section 377A issue. Regardless of our views on homosexuality, I think we can generally agree that we know a gay friend or even family member, and we love and respect him like we do any other friend or family member. And we have very little reason, really, to see him as a criminal. I believe this is the prevailing morality of our society, and because our laws ought to reflect the morality of our society, repealing Section 377A and decriminalizing gay sex is really the right thing for us to do. And I'm glad we are doing it. Now, we could very well stop here. Legislatively, there is no obligation or inevitability that as we decriminalize gay sex, we will also protect the institution of marriage. It is a deliberate act of Parliament, a carefully considered and balanced decision and move, to do both at the same time. And we do it because we know that taken together, this set of arrangements will be one that our society as a whole can probably accept, and it can point a way forward for all of us. Going back to the story of my two friends, the young parents, yes, if their son does turn out to be gay, they will certainly not want their son's private activities to be criminal, but I think it will be much less certain if they will accept the notion of a son-in-law or of a grandchild or grandchildren within the context of a marriage between their son and his gay partner. And I think they would also completely understand if their friends were to turn to them and say, look, we really will not agree to allowing your son to marry here in Singapore because it runs against our beliefs and it runs against what we would like our children and our grandchildren to believe about marriage, or at least what we would like our children and grandchildren to see and hear for themselves before forming their own conclusions. On marriage, I think this is the prevailing morality of our society, and our laws and policies should also protect this, even as we repeal the law on gay sex. Indeed, it seems from a survey conducted by Today just 2 months ago that younger Singaporeans generally think this way too. 68% view the repeal of 377A positively, and at the same time, an almost equal proportion wishes to uphold the current definition of marriage between one man and one woman. Now, let me also say this. Some have commented that this is effectively, where we are today, is effectively one step forward and 2 steps back for the gay community. I have to respectfully disagree. I think this is real progress. Gay sex is decriminalized in Singapore, finally, and at the same time, we are coming together as a society and coming to terms with the reality that a majority of us are not yet ready to give up our fundamental beliefs, including on marriage, and so let's find a balance. Let's find mutual accommodation. This is a mark of our maturing society. This is real progress. Now, some, on the other hand, have characterized the repeal as a capitulation by the government and society at large to the relentless campaigns and militant advocacy of some gay rights activists. I think this is quite unfair too. I believe instead that this change is about all of us, our society as a whole, maturing, progressing organically. Change takes time, and this change has taken quite some time. But this change has not been precipitated by the narrow words or actions or deeds of a few. I think this change represents part of our broader progress towards becoming a more inclusive society in various dimensions, various other dimensions like wage level, age, disabilities, mental health, and yes, we have become more inclusive on the dimension of sexual orientation too. Sir, in Mandarin, please. 议长先生，为人父母的是想想，如果有一天您的儿子告诉您，爸妈，我是同性恋，我有伴了，我想带他来见你们，您会怎么想？您会怎么说？这或许是很纠结、很令人折腾的一个设想，我也不愿任何为人父母的会经历这样子的考验。但是如果这正是当前的事实，那我猜想我们的反应，首先应该会是：第一，我们对孩子的爱仍然不变；再来，我们也绝对不会希望儿子会因为他的性倾向和性行为被视为罪犯。这第二点正是刑事法典377A 条文折射的核心问题。无论我们对同性恋、对男男恋爱有怎样的态度和理念，我们生活圈子里应该都有认识同性恋的朋友，甚至是亲人。他们就像任何人一样值得被疼爱，一样值得被尊重。我想我们也可以认同，我们没有什么理由为依据，可以把他们男男之间私底下的性爱行为视为刑事罪行，这是不人道、不正义的。所以我支持废除377A 条文，这是我们作为一个包容社会应该做的，责无旁贷。当然，我也非常理解，很多国人会担忧废除377A 之后会有怎样的后果。同性恋人权主义者又会有怎样的提倡和争论？如果废除377A 之后的下一步是同性婚姻的认同和许可，我们现今社会的规范和核心价值理念又该何去何从？国人的这些顾虑是非常根本、非常重要的。也正因如此，政府在废除377A 的同时，也提议修正宪法，保护目前的婚姻定义。昨天，政务部长孙雪玲也指出了，这反映了政府就377A 课题以及在顾及社会各个群体的担忧和考量中所投入的极大心思。我想说的是，这两项法案同时也反映了一个负责任的政府和国会应有的政治勇气、骨气和魄力。377A 课题虽然困难，我们并没有退缩，我们并没有失责。古人有句话：“治国有常而利民为本，政教有经而令行为上。”治国有常而利民为本，说的就是治国最根本的法则是让人民获利。那政府坦然正视问题，寻找折中的方向，通过这两项法案，政府做到了。政教有经而令行为上，意思就是政治教化最紧要的是让政令畅通无阻，让政令畅通无阻。所以，人民行动党在就这两项法案中，并没有举起党鞭。执政党顾名思义就得执政，让政令畅通。执政党做到了。这是我国民主制度和民主过程中属于所有国人的重要胜利。So where do we go from here? My hope is that all sides will continue engaging with each other and do so with ever greater depths of mutual respect, understanding, and empathy. And it starts with avoiding unhelpful assumptions. For one, gays and lesbians are not a monolith. Not all homosexuals are judicial activists. And judicial activists do not speak for all homosexuals. At the same time, not all social conservatives are Christian or Muslim. Indeed, many conservatives are either of other religions or not religious at all. Their socially conservative views, while deep-seated, are not religious in nature. I also hope that our engagements going forward will be in the real world, offline, not in social media where certain narratives get amplified much more than others. Social media creates echo chambers, and not all equally. Some chambers may be small, but the echoes are especially loud, and they reverberate well beyond the realms of the chambers themselves. We have Singaporeans who are concerned with how and what social media is buffeting us with, and I think rightly so. We need safe spaces in the real world where all views can come forth and be heard equally, where we can get a good sense of the real balance of views amongst all of us. And in these safe spaces, no one should have to labor under the fear of name-calling or being cancelled, especially by bad actors under the guise of anonymity. Mr. Speaker, sir, with this, I support both bills. Thank you.
Ms. Nadia Samdin.
Mr. Speaker, sir, I would like to start off my speech by highlighting the significance of this debate being held in this House. The separation of powers is a deeply rooted principle in our parliamentary tradition. Parliament makes the laws, the executive administers the laws, and the judiciary interprets and applies the laws when disputes are brought before the courts. In this House, regardless of personal beliefs, we are duty-bound to represent the different voices of Singaporeans. This is a responsibility that I do not take lightly. Over the past few months, a number of my residents in Cheng San Seletar have written to me, or even come down to my MPS, to express that while they do not believe that acts of intimacy between two consenting men should be a crime, they sincerely wish to preserve the definition and institution of family. Others have shared that removing criminality from homosexuality is long overdue, given that the law was introduced back in 1938. Some have also questioned if there is actually a real possibility of 377A being struck out by the courts, while others have also worried about the wider ripples of this repeal, whether this has potential to change the way that marriage is defined in Singapore, or how sexuality education will be taught to their children. I have also heard stories of gay youth facing discrimination in their friend groups, or struggling to find acceptance among peers who do not have the capacity or vocabulary to understand them, and also of youth who hold more conservative beliefs who've been called out in schools. Sometimes these disagreements occur online, hidden under the cloak of anonymity, which emboldens individuals to speak carelessly. But loud does not always mean right, and some may feel pressured into adopting a view. When issues are contentious, tribes are built and positions are entrenched, and conversations quickly start from an adversarial place. This environment, if left unchecked, do not allow for people to build the capacity to discuss and debate with respect and reconcile even internal incongruence between faith, heart, and mind before coming to their own considered position. While it may be just one section of law and about consensual acts in private, no less, 377A has come to represent much more for many over the years, concerning fundamental values of individuals in a visceral way. As elected representatives, we value every perspective shared with us. As such, This matter, which has been debated in both public and private spaces for many years, even before the 2022 National Day rally, belongs here in this House after years of consultation and engagement in both public and private spaces. Not in the courts, where judges must make decisions based on the information and facts presented before them, resulting in a binary decision. Laws and policies must be guided by a careful balancing of the scales, not having the scales tipped to one side or to the other through judicial activism or driven by individuals with the resources to litigate. I will not belabor this point as it has been raised by honourable colleagues such as Mr. Murali Pillai yesterday. This process of a judiciary intervening actively in social issues may also signal an unwillingness of elected politicians to deal with such issues ourselves and leave such decisions to the courts so that we don't have to assume responsibility for them. In some countries, judicial activism has deepened polarization in societies, for example, over immigration matters in Australia and abortion rights in the US. This also results in judicial appointments themselves becoming politicized affairs. We should not foster this culture in Singapore, and so I agree with the Honourable Minister for Social and Family Development on the approach of this bill. I appreciate that we are dealing with this now. The decision made in 2007 to accept the legal untidiness and ambiguity of keeping the law on the books was the compromise struck by society at the time. Later in 2018, Attorney General Lucien Wong affirmed the public prosecutor would not prosecute two consenting men for having sex in private, giving legal significance to the political compromise struck in 2007. Former Attorneys General Walter Woon and V.K. Raja also separately suggested that it was not desirable for the government and Parliament to direct the AG not to prosecute offences under 377A. And following these comments, AG Lucien Wong clarified that the public prosecutor retained independence in deciding whether to pursue a case under 377A. He shared that while the public prosecutor is entitled to consider public policies in exercising his discretion, these do not fetter the exercise of prosecutorial discretion. In all the feedback I have received, many of our people, regardless of race, language, or religion, agree that acts of intimacy between two consenting men do not make them criminals. We have also generally not seen public interest or organized groups for the active enforcement of 377A. For most, the disagreement lies solely if it should be repealed. So we must ask ourselves objectively, 15 years on, should we accept the legal untidiness and ambiguity, given that over the last 15 years, there's been little public interest in seeing Section 377A enforced? From a legal perspective, it is not quite tenable for us to keep this dead-letter law, and I support the repeal. Sir, I have heard the concerns of those who are seeking for the definition of marriage between one man and one woman to be codified in the Constitution. However, the Honourable Minister for Social and Family Development has elaborated on why such an approach is not the right one for Singapore. For this reason, I can understand the intention of the introduction of Article 156 to the Constitution as part of the package of amendments, which strives to reflect a balance, protecting the existing definition of marriage from constitutional challenges per the majority views today, while leaving space for future generations to make their own decisions based on the context of their time. Sir, societies evolve over time, and leaders must proactively respond to the conditions of the day. The Singapore I grew up in is different from the one of my parents, and I can also appreciate that the Singapore which my children one day may grow up in could be unrecognizable from my lived experiences. To do this, while we may choose to educate and guide our families based on our own personal values, we ought to avoid passing down entrenched positions to future generations, especially in our secular shared space. Sir, in Malay, please. Sejak pengumuman PM Lee Hsien Loong semasa Rapat Hari Kebangsaan 2022 tentang Section 377A, ramai yang telah membincang tentang isu ini dan menzahirkan sokongan dan juga pembantahan. masyarakat Melayu Islam kita bukan komuniti yang monolitik. Setiap generasi mempunyai pandangan, latar belakang dan pengalaman yang berbeza. Dalam perbincangan saya bersama badan-badan dan individu, saya telah mendengar saranan yang berbeza. Saya ingin mengucapkan terima kasih kepada setiap orang yang meluangkan masa untuk berkongsi pendapat mereka bersama saya. Saya juga berpeluang untuk bertemu pemimpin, kaki tangan dan sukarelawan daripada pelbagai badan-badan Melayu Islam kita. Dalam perbualan ini, ramai yang telah menzahirkan harapan agar institusi keluarga dilindung di samping pemansuhan Seksyen 377A. Ada yang berkongsi kebimbangan mereka tentang keupayaan mereka untuk mengurus dan menyokong perbualan antara keluarga mengenai Seksyen 377A. Ada yang kongsi perjuangan peribadi mereka untuk mendamaikan kepercayaan, minda dan masyarakat agar mereka dapat memberikan nilai kepada anak-anak mereka selaras dengan kepercayaan dan cara mereka dibesarkan kerana ia adalah sesuatu yang mereka sayangi. Walau bagaimanapun, mereka tetap bertekad bahawa sebarang bantuan dan perkhidmatan sosial yang diberi harus diberikan atas dasar belas kasihan dan meletakkan kepentingan pada maruah individu tanpa mengira seksualiti. Toleransi dan kepelbagaian yang kita ada di Singapura adalah sesuatu yang kita pupuk dan bina selama bertahun-tahun. Ia wujud hari ini kerana generasi sebelum kita dan juga generasi sekarang akur tentang pentingnya kita mencari kompromis dalam ruang alam awam kita di mana advokasi tidak semestinya harus meruntuhkan satu sama lain. On that note, I would like to finish off my speech to ask not just the members of this House, but Singaporeans at large, where do we go from here, with not just dealing with this repeal, but other issues which may divide us? There are two paths. The first sees us entrenched in our positions, unwilling to engage in constructive dialogue with others who may not see the world the way we do. The second sees us engaging in respectful conversation while remaining steadfast to our own values. Path 1 leads to division, and we have seen the damage this has done in fractured societies. Path 2 leads to understanding, and in turn, peace and a more lasting prosperity. It is a path rarely paved and harder fought, an uncharted territory for many of us. In moments of crisis, we run the risk of deviating back to Path 1. In the context of Section 377A, we move beyond talking about criminality in the same sentence as homosexuality and see people as individuals for who they are. It is easy to say that we must move beyond tolerance and towards understanding, but harder to accept that we can no longer steer clear from speaking on contentious issues. I ask that we endeavor to not invalidate the lived experience of others and that we do not fall prey to living in echo chambers. Singapore is not in a special bubble, which makes us immune to these risks, and I do believe that our leaders understand that. As a young nation, we have not had as many years to discuss and debate or come to a landing of what we expect of each other, as well as an understanding of trade-offs. I am hopeful that efforts such as Forward SG will build up the muscle for society to do so, if done well. And such sessions are an important part of setting up a two-way mode of engagement between the government and people, where engaging in productive dialogue with varying points of view becomes the new normal. In closing, there are many ways to create change. Sometimes it requires us raising our voices. Most times it requires persistence and tough conversations. And always it involves time, a big heart, and the willingness to hear each other out. Ultimately, change should not be born out of or led by fear, as fear will not protect us. I echo my honourable colleague MP Joan Pereira's sentiments that we should come from a place of love, and I would add also about courage. Knowing that there are diverse groups who feel strongly about this, I hope that we can continue to be brave, to have the tough conversations with mutual respect for our fellow Singaporeans. Thank you for allowing me to participate in the debate.
Mr. Abdul Samad.
Mr. Speaker, Prime Minister Lee first announced in his National Day rally speech on August 2022 that Section 377A would be repealed. Since then, this matter has been deeply debated by members of the public as well as members of this House. Based on my interactions with my friends, colleagues, union leaders, and members, I have gathered that there are sentiments of worry and unhappiness among Singaporeans on this topic, despite the many engagement sessions carried out earlier involving various groups of leaders and fellow Singaporeans. We have heard yesterday from more than 20 MPs and NMPs on this thorny and sensitive subject matter. I am heartened by the passion and conviction of the various speeches by the members of this House and their commitment to safeguard the natural institution of marriage and family structure as reiterated by many. On the other hand, I am also comforted knowing that we are according the necessary space to those who had previously felt oppressed by the existence of Section 377A in our books. I would like to thank both Minister Mas Agus for his explanation on the implications of the insertion of a new Article 156 into our Constitution with regards to marriage, as well as Minister Shamugam's explanation on the importance of repealing Section 377A in this House instead of being struck down by the court. In fact, many in our society may not have known that prior to this announcement, there have been constitutional challenges filed in court against Section 377A on the basis that it violates the Constitution. PM Lee also mentioned during his National Day rally speech that the Attorney General and Minister of Law have advised that in the future court challenge, there is a real risk of Section 377A being struck down. Sir, our union members and fellow workers are also residents of all the MPs here. They too shared their concerns with me either in person, over calls, messages, or even emails. I have received emails from multiple individuals and groups calling for the retention of Section 377A. This view is commonly held by more conservative and or religious groups as they are concerned with what the repeal of Section 377A represents, that there would be an erosion of family values, and the traditional definition that marriage is between a man and a woman could be challenged. There is also another view that the government should not intervene nor police private and sexual behaviors between consenting adults. Accordingly, it should be removed from our books, especially if the government will not actively enforce it. With all being said, I hope the government can enlighten laypersons like myself on the relevant processes for legislative and policy reforms. Under what circumstances would the court be empowered to strike down the laws passed by Parliament? What can be done by Parliament to avoid the striking down of the laws? Should the matter be canvassed before Parliament, for Parliament to consider repealing the same first? What is the difference between these two processes? Can an infographic illustrate these processes to make it easier for people out there to understand? Nevertheless, I am glad that this issue is canvassed before us presently, as such a law which has far-reaching implications on Singapore's family structure and societal norms should be decided by Parliament, which has the people's mandate and not the courts, which only interpret and apply laws passed at the Parliament. At the same juncture, I applaud the government's decision of introducing Article 156 into our Constitution. Article 156(2) provides that the government and public authorities may, in exercising their executive authority, protect, safeguard, support, foster, and promote the institution of marriage. This is wholly consistent with what most Singaporeans want, which is to maintain the current family and social norms, where marriage is between a man and a woman, and children are brought up in such a family structure. We hope that the existing measures, such as public housing policies and financial benefits for married couples, as well as education and media policies, continue to promote and safeguard the institution of marriage. So I will now speak in Malay. Tuan Speaker, perbincangan kita berkenaan pemansuhan Seksyen 377 dan perubahan pada perlembagaan negara telah menarik perhatian di kalangan masyarakat kita. Tidak kira bangsa dan agama, ramai yang melahirkan kebimbangan tentang cara kehidupan masyarakat kita sekiranya permansuhan Seksyen 377 ini diluluskan. Sedihnya tak ramai yang beri perhatian yang sama akan pemindahan perlembagaan dengan penambahan artikel 156 yang menerangkan serta mengukuhkan definisi perkahwinan dan keluarga. Ramai yang bertanya-tanya apakah pemerintah bersetuju dengan perbuatan golongan sedemikian sehingga akur dan tunduk pada permintaan mereka. Kita semua sedar akan kemunculan semula golongan serupa ini dan ia amat membimbangkan buat masyarakat kita sekarang dan pada masa hadapan. Pemansuhan akta ini boleh dilihat sebagai kejayaan kecil buat golongan ini. Apakah mungkin di masa hadapan mereka akan terus membuat permintaan yang lebih atas dasar hak asasi yang sama untuk semua masyarakat? Apakah pemerintah akan juga menyokong dan mengizin sama seperti keadaan sekarang? Memang tidak salah untuk melahirkan kebimbangan. Namun kita harus akur bahawa dunia ini milik semua makhluk ciptaan daripada manusia, haiwan, gunung ganang, tumbuh-tumbuhan dan selebihnya yang tak mampu kita hitung. Golongan seperti ini juga manusia biasa macam kita juga. Kita wajar kongsi bersama kelapangan dunia ini sama seperti semua ciptaan Tuhan. Janganlah kita asingkan mereka hanya kerana keadaan nafsu mereka berlainan dengan kita. Sebarkan sifat rahmah di kalangan manusia dan mengenali cabaran mereka. Mereka tidak pernah minta untuk berada dalam keadaan sedemikian. Tetapi kita yang mengaku diri kita waras dan siuman harus memainkan tugas menasihati dan berkongsi dengan mereka fitrah kehidupan sebenar. Ayo kita tanamkan sikap hormat menghormati, bukan menghukum, atas dasar perbezaan pendapat, pendirian serta kepercayaan masing-masing. Kita harus elakkan dari menyebarkan fitnah yang boleh memecah belahkan masyarakat kita. Perpaduan harmoni dalam masyarakat yang telah lama dibina atas dasar hormat menghormati harus dijaga dan diperkasakan. Bersatu teguh, bercerai roboh. So I am sure that the repeal of the Section 377A will bring some form of relief and comfort to those who had previously felt oppressed by the same, in knowing that our societal norms have shifted and we as a society are ready to accept and grant them the space needed. In my personal view, the government has arrived at a nice balance, granting homosexuals the space that they need through the repeal, while recognizing and upholding the traditional definition of marriage through the constitutional amendments. In closing, I echo what our Prime Minister said at the National Day rally, that we must maintain the mutual respect and trust that we have painstakingly built up over the years and stay united as one united people. I stand by and support the decision to repeal Section 377A, as well as amendment to the Constitution, because every human matters. I also call on fellow workers and employers to treat every worker equally, regardless of their gender, because every worker matters. Thank you.
Minister of State Faisal Ibrahim.
Mr. Speaker, in Malay, please. Sepanjang beberapa bulan yang lalu, pemerintah secara meluas telah merujuk kepada pelbagai kumpulan berkaitan isu penting ini. Saya telah bertemu dengan para pemimpin Melayu Islam badan-badan Melayu Islam, kumpulan antara agama, kumpulan belia dan pakar-pakar penjagaan kesihatan dalam sesi-sesi pendekatan ini. Para peserta telah berkongsi maklum balas secara jujur dan terbuka. Kebanyakan dalam masyarakat kita, termasuk golongan Melayu Islam, menghargai dan ingin mempertahankan pandangan tradisional sebuah unit keluarga di mana perkahwinan antara seorang lelaki dan seorang perempuan dan anak-anak dibesarkan dalam suasana kekeluargaan tersebut. Pemerintah memberikan sokongan penuh kepada hal ini. Pendirian kami berkenaan perkahwinan dan kekeluargaan adalah jelas dan hal ini sejajar dengan dasar-dasar dan undang-undang kita. Definisi perkahwinan konvensional termaktub dalam undang-undang kita di dalam Piagam Wanita iaitu Women's Charter dan Akta Pentadbiran Undang-Undang Islam (AMLA). Kebanyakan dasar-dasar di Singapura berasaskan definisi tersebut termasuk pengambilan anak angkat, perumahan, pendidikan dan media. Dengan pindaan perlembagaan, pemerintah sedang mengambil langkah-langkah untuk melindungi definisi perkahwinan dan cabaran-cabaran yang timbul daripada undang-undang dan dasar-dasar yang berkaitan dengan pindaan perlembagaan. Langkah ini memastikan bahawa sebarang perubahan kepada definisi perkahwinan boleh dibahaskan dan ditentukan menerusi parlimen dan bukan melalui mahkamah. Jika kita lihat pada pelbagai cabaran yang dihadapi Seksyen 377A selama ini, kita boleh jangkakan cabaran yang serupa dengan definisi perkahwinan dan undang-undang dan dasar-dasar yang bersandarkan definisi tersebut. Keputusan sedemikian tidak patut dibiarkan kepada mahkamah untuk membuat keputusan. Di dalam ucapan rapat umum Hari Kebangsaan, Perdana Menteri mengumumkan bahawa para hakim tidak mempunyai kepakaran maupun mandat untuk menangani persoalan politik ataupun membuat keputusan terhadap norma-norma dan nilai-nilai sosial. Menteri Masagos di dalam ucapannya sebelum ini memetik contoh Amerika Syarikat dan India di mana keputusan mahkamah boleh membawa pada sebuah situasi menang kalah bagi masyarakat. Jika kita tidak mengambil tindakan untuk melindungi institusi perkahwinan dan membiarkan kepada pihak mahkamah, kita mengambil risiko merosakkan asas masyarakat kita, iaitu struktur kekeluargaan. Dalam hal penting seperti isu-isu sosial, Parlimen lebih layak untuk menanganinya. Parlimen boleh merujuk kepada pelbagai kumpulan, mengambil maklum balas dan menilai cara yang terbaik untuk maju sambil mengimbangi pertimbangan masyarakat dengan lebih meluas. Pada dasarnya, undang-undang pro keluarga harus diputuskan oleh Parlimen, bukan pihak mahkamah. Saya telah berkongsi ini semua bersama masyarakat Melayu Islam semasa sesi-sesi pendekatan saya dan kebanyakan mereka memahami dan mengalu-alukannya. Sebagaimana yang dijelaskan oleh Menteri Shanmugam dalam ucapan pembukaannya, kami sedang menuju ke arah pemansuhan Seksyen 377A. Semasa sesi pendekatan saya, ada beberapa, termasuk dari golongan masyarakat Melayu Islam, yang berkongsi keprihatinan bahawa pemansuhan Seksyen 377A akan membawa perubahan yang besar kepada undang-undang dan dasar-dasar yang lain dan mencetuskan peralihan yang mendadak kepada masyarakat kita. Ada juga yang berkongsi kebimbangan pemansuhan Seksyen 377A akan merobohkan benteng dengan perkahwinan seks sejenis dan pembentukan keluarga pasangan seks sejenis, menormalisasikan LGBT dalam masyarakat, membawa kesan secara tidak langsung kepada pendidikan seks di sekolah, menormalisasikan penggambaran hubungan LGBT di media dan sebagainya. Saya ingin meyakinkan masyarakat bahawa tiada sebarang perubahan pada pendirian pemerintah terhadap perkahwinan dan kekeluargaan akan berlaku. Pemerintah juga tidak ada rancangan untuk mengubah definisi perkahwinan untuk melibatkan perkahwinan seks sejenis. Sama juga dengan dasar-dasar yang berasaskan definisi terkini tentang perkahwinan. Ia kekal tiada perubahan. Ini juga telah diumumkan oleh Perdana Menteri dan Timbalan Perdana Menteri Lawrence Wong bahawa pemerintah ini tidak bertujuan untuk mengubah definisi perkahwinan maupun dasar-dasar yang berasaskan definisi tersebut. Anda mungkin tertanya, mengapa kini Seksyen 377A dimansuhkan? Izinkan saya menerangkan secara ringkas mengapa pemerintah mengambil keputusan untuk memansuhkan Seksyen 377A dan melindungi definisi perkahwinan. Pertama, pemansuhan Seksyen 377A adalah perkara yang betul dan berprinsip untuk dilakukan. Pada dasarnya, tidak ada masalah undang-undang dan keamanan berkaitan dengan kelakuan homoseksual dewasa yang suka sama suka secara tertutup. Masyarakat telah berubah sejak kali terakhir Parlimen membahaskan Seksyen 377A pada tahun 2007. Pada masa itu, masyarakat kita belum bersedia, tetapi pendekatan kami sepanjang beberapa bulan yang lalu menunjukkan bahawa kebanyakan rakyat Singapura hari ini menerima bahawa seks antara lelaki bukan sesuatu jenayah. Walaupun kita mungkin secara peribadi menentang kelakuan homoseksual, kita harus akur dengan Seksyen 377A sebagai sebuah undang-undang yang menjadi penanda stigma kepada mereka yang homoseksual dan juga sebagai peringatan yang mereka tidak diterima oleh masyarakat. Menghilangkan punca tekanan psikologi dan fizikal daripada kehidupan mereka adalah langkah yang betul agar kita boleh maju ke hadapan sebagai sebuah masyarakat yang saling menghormati keluarga, rakan-rakan dan teman sekerja kita yang homoseksual. Kedua, seperti mana dijelaskan oleh Menteri Shanmugam, terdapat risiko yang ketara bagi Seksyen 377A dibatalkan oleh pihak mahkamah atas dasar bahawa ia melanggar fasal perlindungan sama rata perlembagaan. Ketiga, jika Seksyen 377A dibatalkan oleh pihak mahkamah, definisi perkahwinan kita, undang-undang dan dasar-dasar yang berkaitan dengannya akan tertakluk pada cabaran undang-undang yang serupa. Mengambil kira kesemuanya, pindaan perlembagaan dan pemansuhan Seksyen 377A mencerminkan pendekatan yang diambil oleh pemerintah untuk mengelakkan definisi perkahwinan daripada diubah oleh pihak mahkamah sambil melakukan perkara yang sepatut dan sebaiknya supaya dapat mengekalkan perpaduan serta kohesi masyarakat. Awal tadi saya menyentuh beberapa keprihatinan utama yang dikemukakan oleh masyarakat Melayu Islam berkaitan pemansuhan Seksyen 377A dan implikasi yang berkemungkinan terjadi. Saya juga ingin menjelaskan bahawa tiada perubahan kepada undang-undang dan dasar-dasar yang berkaitan dengan perkahwinan kerana ia bukan tujuan pemerintah untuk menyebabkan peralihan yang tidak stabil ke dalam masyarakat kita. Izinkan saya memberi sepatah dua kata mengenai maklum balas yang diterima oleh pemerintah semasa seksi pendekatan kami. Pertama, Saya memahami masyarakat Melayu Islam ingin melindungi nilai-nilai agama dan kekeluargaan. Berkenaan ini, saya ingin merujuk kepada panduan keagamaan daripada Mufti baru-baru ini berkaitan dengan isu LGBT. Mufti menjelaskan bahawa dalam Islam, hanya hubungan seksual antara suami dan isteri dibenarkan. Saya bersetuju nilai ini harus dilindungi dan digalakkan. Pada masa yang sama, Mufti turut akui bahawa kita hidup dalam masyarakat majmuk dan kita harus menghormati perbezaan pada pandangan dan tunjukkan peri kemanusiaan kepada orang Muslim yang bergelar LGBT. Sebagai seorang Muslim, kita harus berbuat baik dan menunjukkan rasa empati kepada saudara Muslim kita yang mempunyai pandangan yang berbeza dari kita. Kedua, ada yang bimbang bahawa desakan untuk hak LGBT akan melanggar kebebasan keagamaan. Saya ingin jelaskan bahawa pemansuhan Seksyen 377A tidak akan menjejas kebebasan masyarakat Melayu Islam mengamal agama dan kebebasan ini akan terus dilindungi perlembagaan. Para pemimpin masyarakat Melayu Islam dan asatiza boleh terus bebas berdakwah tentang pegangan Islam terhadap homoseksualiti, termasuk melakukannya secara maya untuk melibatkan lebih ramai belia dalam hal ini. Asalkan ianya dilaksanakan secara berhemah, tidak melampaui batas dan mengundang keganasan atau kebencian terhadap orang lain. Masyarakat harus juga merujuk kepada panduan yang disediakan oleh Mufti. Yang penting sekali, saya ingin menegaskan bahawa kebebasan mengamal agama mesti diimbangi dengan sifat saling menerima, menghormati, berperi kemanusiaan dalam masyarakat majmuk kita. Ini amat penting untuk mengekalkan perpaduan sosial. Dalam hal isu-isu sensitif, kita bebas untuk tidak bersetuju antara satu sama lain dan kita harus diberi ruang untuk mengemukakan pendapat dan keprihatinan. Namun begitu, dalam kita mengemudikan pandangan-pandangan yang berbeza, kita harus mematuhi prinsip-prinsip saling memahami, hormat, bertolak ansur dalam interaksi sebegini, supaya kita boleh mewujudkan dialog yang konstruktif untuk memajukan masyarakat kita. Di dalam satu wawancara sebelum ini, Mufti mengulas bahawa pemansuhan Seksyen 377A merupakan isu sosial yang rumit dan susah untuk mencapai keseimbangan bagi semua pihak, termasuk pemerintah dan kumpulan-kumpulan agama. Sebagai sebuah masyarakat, kita mesti terus dapatkan bimbingan dan nilai-nilai dari ajaran Islam dari segi pertuturan dan perbuatan meskipun berlaku perubahan dalam undang-undang negara. Kita harus berhati-hati untuk tidak menjadikannya isu perbahasan yang bakal merenggangkan hubungan baik antara kaum yang kita susah payah bina selama ini. Sebagai pemimpin yang beragama Islam, kita tidak seharusnya fokus pada pandangan pribadi kita dan menarik hati masyarakat kita sahaja. Akan tetapi, kita juga harus mempertimbangkan secara keseluruhan apa yang terbaik untuk masyarakat kita dengan menimbangkan pandangan daripada masyarakat Singapura secara keseluruhannya. Ini untuk memastikan perpaduan yang seluruhnya dan membolehkan kita untuk sama-sama maju ke hadapan. Selaras dengan apa yang dikatakan oleh Mufti, walaupun homoseksualiti adalah satu dosa, masyarakat tidak boleh menolak dan mengetepikan mereka. Kita seharusnya kekal berprinsip dan seimbang, walaupun kita mempunyai pendapat yang berbeza dan melihat apa yang terbaik bagi masyarakat secara keseluruhannya. Inilah sebabnya mengapa pemerintah menyokong kedua-dua pemansuhan Seksyen 377A dan pindaan perlembagaan untuk melindungi perkahwinan. Dalam kita bergerak ke hadapan, saya menyeru kepada semua supaya bertenang dan bersikap sederhana sambil kami berusaha mencapai persetujuan untuk kemajuan Singapura sebagai masyarakat bersatu padu sebagaimana yang sentiasa kita lakukan. Saya juga ingin mengucapkan terima kasih kepada para pemimpin masyarakat dan rakan-rakan kerja kerana berkongsi pandangan mereka dan memberi sokongan kepada pemerintah tentang perkara ini. Kami telah mendengar luahan mereka dan akan terus bekerja rapat dengan mereka untuk menghadapi hal ini. Saya rasa terharu dengan sikap mereka untuk terus mengukuhkan ekosistem pembangunan negara kita, walaupun kadang-kala kita menghadapi isu-isu yang rumit. Terima kasih, Tuan Speaker.
Mr. Lewison.
Sir, the repeal of Section 377A holds great significance for many across the social and religious spectrum. The heated civil discourse and vigorous advocacy speaks to strongly held belief that many hold on this issue. This has been an opportunity for Singaporeans to learn to disagree in a spirited but civil way. I believe that such open debate is a sign of a healthy and functioning democracy. However, in doing so, we cannot lose sight of our shared humanity. I can do no better than to quote Muiz. In response to the repeal of Section 377A, it said that Muslim law, quote, places importance on human dignity, respect, and peaceful relations, unquote. It further said, quote, these values are crucial as we navigate complex social-religious issues today. As Muslims, we should treat everyone with full dignity and respect. Everyone, regardless of their sexual orientation, must feel safe in our society and institutions. Muslims should uphold the best of character, charity, and compassion in dealing with others, even with whom we disagree, unquote. I believe these statements apply not just to those of the Muslim faith, but to all of us. As we continue to engage on discrimination against the gay community and discrimination of any form, I hope we continue to treat each other with dignity, respect, and kindness. In doing so, we cannot shy away from having conversations with people whom we do not identify with. We need to continue the dialogue on issues affecting the gay community with the intent of achieving progress for everyone. For the gay community, the repeal of Section 377A is the correct thing to do. It is correct not only because of the likelihood of success of any court challenges. It is the correct thing to do because gay Singaporeans deserve, like any other member of society, not to be criminalized for their private behavior. The repeal of Section 377A is a positive step towards making Singapore a more equal and inclusive society. We should recognize and thank the collective effort of activists and organizations over the years to raise awareness about the challenges that the gay community face and foster acceptance of gay individuals within our society. We need to continue to have conversations about this issue as our nation progresses. So I have 3 points of clarification on both bills. My first point is on the treatment of prior convictions under Section 377A. In his National Day rally speech, when he announced the intended repeal of Section 377A, PM Lee said he believed that the repeal is the right thing to do, and it would provide relief to gay Singaporeans. Minister Shanmugam has also said that it is wrong to continue criminalizing the sexuality of gay Singaporeans and what they do in private. Nobody, he said, deserves to be stigmatized because of their sexual orientation. So repealing 377A and removing their plane is the right thing to do. If the continued stigmatization of gay Singaporeans is wrong, then the continued stigmatization of gay Singaporeans because of their record of conviction under Section 377A must also be wrong. Under the Registration of Criminal Acts, an offence under Section 377A is a registrable crime. Any criminal record of conviction under Section 377A will become spent after a crime-free period of 5 years. An exception is if the person is disqualified from having their criminal record being spent. As such, this may mean there may be individuals with existing records of conviction under Section 377A because the conviction was within a 5-year period or because the individual is disqualified from having their record being spent. These individuals may, due to the record, remain stigmatized, even as we repeal Section 377A. Can Minister clarify if there are any individuals with existing records of conviction under 377A and who has not been spent? Can Minister clarify how these prior convictions will be treated? My second point is support provided to students of diverse genders. The repeal of Section 377A sends a strong message against the discrimination of gay Singaporeans on the basis, again, of their private behaviour. As Minister Shanmugam shared, this legislative step is a significant step in removing stigma on a legislative level and will also go some way in removing hurt. However, discrimination and stigma do not just exist in abstract policies. Many individuals of diverse gender face discrimination, stigma, and hurt in their day-to-day interactions in the community and even with their closest loved ones. These challenges can be especially daunting for young students who are just starting to build their identity and navigate their teenage years, which can already be a stressful experience for anyone. Many surveys, both local and international, show that many individuals of diverse gender experience symptoms of generalized anxiety disorder. Many also experience major Many also experience major depressive disorder and engage in self-harm. Our teachers and counselors in schools are a first line of defense in identifying students who may be struggling from such stresses and challenges. They're also well placed to facilitate appropriate intervention. Can ministers share what support has been or will be extended to such students? In particular, what role will teachers, counselors in school play in identifying students of diverse genders who may be struggling and extending such support to them? My final point is on the new Article 1561 in the Constitution. It enables the legislature and the government to define, regulate, protect, safeguard, support, foster, and promote the institution of marriage. In the explanatory statement, examples of such activities included housing preference and financial benefits for married persons, and education and media policies that promote and safeguard the institution of marriage. As we encourage marriage, I hope we do not discriminate against single parents, whether they are unmarried, divorced, or widowed. I'm glad Minister Masagos provided some assurances on this during his opening speech that single parents will not be left behind. Indeed, increased support for single parents is one of the main recommendations in the white paper on Singapore's women development, published this year by the government. I've raised recommendations on housing policies to ensure single unwed parents and their children will have a roof over their head. I've also asked for single unwed parents to receive the parenthood tax rebate, the working mother's child relief, and the cash component of the baby bonus. It is a whole suite of parenthood policies that exclude and discriminate against single unwed parents. There is a lot more we can do. Can Minister confirm that even as the government takes steps to define, regulate, promote, safeguard, support, foster, and promote the institution of marriage, we will also continue to review our policies to ensure that single unwed parents are adequately supported? So notwithstanding these clarifications, I stand in support of both bills.
Ms. Janet Ang.
Mr. Speaker, I appreciate the opportunity to participate in this debate. I'm mindful that the subject concerns sensitive matters of religious beliefs, sexuality, and identity. I stand to speak what I believe and beg the indulgence of everyone who may not necessarily hold the same view. We all have friends and family who may hold a liberal view or a conservative view when it comes to matters concerning sexuality and morality. At the same time, we all have friends and family who are LGBTQ persons. The long public debate of the status of Section 377A of the Penal Code has weighed heavily on all sides and has divided our society and even families. To see the half cup full, I would say that during this time, especially since 2018, parties holding differing views have learned more about each other's perspectives and engaged with the government, in dialogue with the government, directly or indirectly with one another. The government has listened, and the proposed amendment to the Constitution, along with the repeal of 377A of the Penal Code, will soon bring the debate to a legislative closure. I hope that after today's debate and after this House has decided, we will move forward together as one Singapore, upholding our pledge to be one united people, respecting each other's dignity as human persons, and upholding the Singapore family built on marriage between a man and a woman and the children they birth and raise to be the bedrock of our society. I declare I am a Catholic and have been brought up knowing that my Creator is a loving God and He loves everyone. The Catechism of the Catholic Church teaches Catholics that the men and women who have deep-seated homosexual tendencies must be accepted with respect, compassion, and sensitivity, even as they are called to chastity. Pope Francis, in his encyclical Amoris Laetitia, The Joy of Love, wrote, and I quote, "We would like before all else to reaffirm that every person, regardless of sexual orientation, ought to be respected in his or her dignity and treated with consideration, while every sign of unjust discrimination is to be carefully avoided, particularly any form of aggression and violence." End of quote. The Catholic Church's position is clear. Homosexual acts are sinful, but homosexual orientation is not. The Archbishop of Singapore, His Eminence Cardinal William Goh, in a statement in August 2022, after PM's National Day rally speech on this matter of repealing 377A, has come out to say that the Church is against the criminalization of LGBTQ+ people, and so supporting the repeal of 377A is not the issue. Rather, the issue is with regards to the rights as a Catholic Church to teach and practice our beliefs regards the family and marriage as defined between a man and a woman according to natural law. As we have all heard over these 2 days in Parliament, his concerns and this issue matters to more segments than just the Catholic Church. Several honourable MPs have referred to the youth survey conducted in September by News Media Today. Here's an excerpt from the news report, and I quote, "The demographically representative survey, which polled 1,000 respondents aged between 18 and 35, was carried out between September 5th and 16. Almost 7 in 10, 68% of youths polled said that the repeal of Section 377A of the Penal Code, which criminalizes sex between homosexuals, is positive for inclusivity in Singapore. But when asked if same-sex marriage is wrong, the respondents were generally divided, with 37% agreeing or strongly agreeing with the statement and 33% disagreeing or strongly disagreeing. The remaining said that they were neutral. At the same time, 62% of the respondents felt that it was important to uphold and safeguard the definition of marriage as that between a man and a woman." Unquote. There have been various polls done over time, and while they may not all be statistically significant, I believe they do sufficiently tell the story. First, the Singaporeans are sympathetic towards decriminalizing gay sex. 2, Singaporeans are divided on the acceptance of same-sex relations. And 3, majority of Singaporeans, both young and old, believe that it is important to uphold and safeguard the definition of marriage as that between a man and a woman. After much prayer, research, and listening to many, including my own daughters, repealing 377A is the right thing to do, and doing so will send a statement to the LGBTQ community that they are safe being who they are, even if their behavior may not be accepted by the mainstream community in Singapore. Supporting the repeal is not the issue. As many in the House have said, the removal of anti-gay sex laws in some countries saw the issue of same-sex marriage falling under the spotlight. And there are large segments in Singapore who care deeply about marriage as defined currently between a man and a woman, as well as family norms such as how children are brought up and what is taught in school. Most people have come to accept that gay sex is a matter of private individual choice. Same-sex marriage, however, is effectively changing a social institution contrary to what most Singaporeans believe and are ready to accept. For me, marriage is a sacred bond between man and woman, committing fidelity to each other so long as they both shall live, and bringing forth children to form a family and fulfill the natural order of the transmission of life. In fact, this Parliament has declared 2022 as the Year of Singapore Families. Singapore families want to be confident that in Singapore, we will be able to freely guide our children on what we believe to be right and wrong. Likewise, for us Catholics, the Catholic Church needs to be confident that her rights to preach and to teach in the parishes and Catholic schools according to Catholic beliefs will be protected. As we have heard in these past days, the same is true for other religious communities and even for non-religious Singaporeans. I would therefore like to ask the Minister to clarify a few points to help address concerns and worries in the minds and hearts of Singaporeans, even as we move to support the repeal of 377A. A. With the amendment to the Constitution, are there still circumstances where the definition of marriage as that between a man and a woman can be subjected to challenge? What are those circumstances, and how will the government deal with such circumstances? B. Will the Christian and Catholic churches be assured that they will continue to be free to preach against gay sexual acts? Cardinal William Goh has spoken of his concerns that we may be drawn into a situation as in the West, where we cannot even say that a same-sex relationship is wrong. For the Catholic Church, this would not be acceptable, as the Church must have freedom to continue to teach in the Catholic schools and from the pulpit what we believe and practice what we teach. C. How will MOE handle sexuality education in our schools, both public and private, and assure Singaporeans that Singapore's family and social norms based on traditional Singaporean values be protected? Bullying and cancel culture must not take root in our educational institutions and our society. D. We should not allow a culture where people of religion are ostracized, attacked for espousing their views or their disagreements with LGBT viewpoints, and vice versa. Singapore has worked hard to create inter-religious harmony in our society. How will the government protect and safeguard this precious strength and asset of our country? Let me close by reiterating my desire that after today's motions are carried, the LGBTQ community amongst us will feel reaffirmed that they are safe being who they are. And together, all of us as Singaporeans, we will rise above differences in views and beliefs and respect each other's dignity as human persons. We will work together to prevent cancel culture to take root in our educational institutions, our workplaces, and our society. We will maintain our religious freedom to practice and teach what we believe to be right and wrong. We will uphold Singapore's societal norms where marriage is a union between a man and woman, and that married couples live as role models for their children and children's children. And we will not disregard the importance and essential need to have the holistic family as the bedrock of our society. And finally, we will continue to dialogue, to listen with compassion and kindness to one another. Mr. Speaker, notwithstanding my clarifications, with hope and trust, I stand in support of the amendment to the Constitution and the repeal of the Penal Code 377A. Thank you.
Mr. Louis Chua.
Mr. Speaker, I welcome the move to repeal Section 377A of the Penal Code. For too long, the law has remained in our statutes explicitly stating that sex between adult men is a crime, even if it's consensual and done in private. Despite the government having said multiple times in the past that it will not enforce the colonial-era law, and with the Court of Appeal ruling earlier this year that Section 377A was unenforceable in its entirety, its existence has very real repercussions that affect many of our fellow Singaporeans, their families, and their loved ones. The topic of this debate is a complex and multifaceted one, with individuals, including members of Parliament, holding deep personal convictions. Yet beyond the bills and clauses themselves, we must also be cognizant that the issues we are debating have far-reaching effects into the personal lives of our fellow Singaporeans. It is on this note that I wish to touch on some aspects of the lived experience of our LGBTQ community in Singapore, which may be less apparent to those of us who are not from within the community. I am a young father with a loving and happy family. Section 377A never really bothered me in any way that I live my life. But over the years, I've gotten to know several members of the LGBTQ+ community, some of whom have become my close friends. The daily struggles they face regarding their sexual orientation and gender identity are very real. We all live in a largely heteronormative world. For my LGBTQ+ friends, that means they constantly face subtle judgment, discrimination, apathy, and hatred even towards them at home, at school, in the military, and at work. Seemingly nondescript questions of bring your girlfriend to drinks next time, or where's your husband, or do you plan to have kids, can come up suddenly at family gatherings or happy hour drinks at work and make them squirm. Think about those awkward Chinese New Year conversations that you have with distant relatives at various stages of your life, be it when you are single, married but without children, or even married with one child and replicate it throughout the rest of the year. These questions become even more damaging, especially when they're unsure of how others would react to their true sexual orientation or gender identity and potentially affect their opportunities at work and in society. So some choose to hide their true selves and avoid talking about who they're dating and their hopes and dreams to lead a stable life. They stay hidden from society. Some choose to be public about it, but fear the risk of being punished for their choices by not being considered for promotion at work or being bullied at school. In some form or another, individuals who identify as LGBTQ+ have to cope with additional mental and emotional stress, and in some cases, physical abuse just for being someone they were born as. Mr. Speaker, it's been well documented that LGBTQ+ individuals are at a higher risk of depression and mental and physical health dangers. Some suffer from internalized homophobia, where they loathe themselves over a sexual orientation or gender identity they had no choice over. A recent NUS public health survey found that among 570 sexual minority young adults aged 18 to 25, 59% had contemplated suicide, and 14% had attempted to kill themselves. Having 377A in our laws means that it's hard to organize support groups to help not just members of the gay community, which is who the law targets, but also the wider LGBTQ+ community who face discrimination, bullying, or mental struggles just for being who they are. Schools and companies may think twice about setting up official LGBTQ+ groups, or at least show overt support in counseling and supporting these individuals. Let us not forget the unfortunate incident from earlier this year, where a school counselor himself presented content discriminating against the LGBTQ+ community before being suspended from all duties pending investigations. The fact that there remains a legal route for prosecuting LGBTQ+ persons has a specific stick sanction chilling effect on the community. Retaining 377A also makes Singapore look anachronistic, especially in light of our Asian financial hub status. Hong Kong's Legislative Council passed legislation decriminalizing homosexual acts in 1991. China repealed similar laws in 1997. Japan briefly made homosexuality illegal and then repealed the law during the Meiji era. Homosexual acts were never a legal issue in Taiwan, while in India, which also shares similar colonial roots in Singapore, struck the law down in 2018. Having 377A made it challenging to convince prominent members of the LGBTQ+ community, Singaporean or otherwise, in the arts, financial sector, tech, and many other areas to remain in Singapore and make meaningful contributions to our society and economy. The LGBTQ+ community's joy of seeing 377A repealed would have been greater if not for the fact that the move merely puts Singapore more in line with other cosmopolitan, open and inclusive societies. In addition, retaining a law that isn't actively enforced or cannot be enforced sends a confusing signal on how one should comprehend Singapore's legal system. It also means that there is always a chance that a future government may attempt to prosecute a man for sex with another man that was done in private and consensual. That is why I applaud the government's move to repeal Section 377A. Some will know that my colleague and fellow Sengkang GRC MP James Lim attended the Pink Dot rally this past June in his personal capacity. As shared in the media release for Pink Dot 14, we are living in an increasingly divided world. The ability to reach across the spaces between us for dialogue, co-created understanding is what will keep us safe. Mr. Speaker, the issue of repealing at its core is not a political one, but one that grants dignity and freedom to a marginalized section of Singapore. And I'm glad that society is indeed ready to move on and repeal 377A. But repealing 377A doesn't mean discrimination towards the LGBTQ+ community disappears overnight. Discrimination against such individuals still exists in Hong Kong, China, Japan, India, and many other jurisdictions where gay sex isn't illegal per se. On the constitutional amendment that is being proposed, the message that Singapore sends is quite clear. The idea that marriage is only between a man and a woman, and this is a decision that will be left for the legislature and society to decide, and not by the courts. For the geographies that I mentioned earlier that have repealed discriminatory same-sex laws, that discrimination still exists is a reminder to us that social acceptance is crucial to any landmark legal or constitutional changes to maintain harmony and stability in society. As such, I do recognize the importance of the signal the new Article 156 sends to provide greater protection for the definition of marriage and its related policies today. After the Prime Minister's announcement at the National Day rally, MCI said that media policies on homosexuality will remain, which means as a Toy Story fan who has enjoyed the entire Toy Story series since 1995, I can't bring my children to watch Lightyear, a Pixar animated children's film, due to overt homosexual depictions, as though homosexuality is unspeakable and cannot be seen. MOE said that the education curriculum will still be focused on what majority of society supports, which is family between a man and a woman. But at the same time, we need to be conscious of LGBTQ+ individuals being invisible in our curriculums. It will take time for society to come together and, as shared by Leader of the Opposition, Mr. Pritam Singh, create conditions for all Singaporeans to succeed and certainly not to feel marginalized, where we are tolerant of Singaporeans who are different in as far as the law allows. But it's all the more important for us to understand each other's viewpoints, stay civil and respectful as we engage all members of society as Singapore becomes more inclusive and open. I had the privilege of hearing from one of our LGBTQ+ advocates recently, and she's a household name who needs no introduction. Ms. Teresa Goh, she shared her incredible journey as a child born with spina bifida to becoming our first female swimmer at the 2004 Athens Paralympic Games, winning gold at the 2006 IPC World Swimming Championships and bronze at the 2016 Paralympic Games. More recently, she has also been elected as one of 10 members of the Singapore National Olympic Council Athletes Commission. While we know her for her extraordinary achievements, what is less well known was the struggles she and her family had to go through as a disabled person and a queer woman here in Singapore. What was particularly heart-wrenching to me was hearing her speak so casually about the difficulties her parents had in searching for a kindergarten for her back in the 1990s, as they faced repeated rejections the moment the kindergartens found out that she had a disability. She shared that there was even one day when she was not feeling well and threw up after lunch, and yet her teacher did not help to clean her up. But she felt that had she been any other normal child, her teachers would have cleaned her up before her parents came to pick her. It is upsetting to hear of such experiences, but I also take comfort in that such behavior would be completely unacceptable and unthinkable in today's circumstances, and we as a society have moved to become more accepting of the disabled since the 1990s. Today, however, LGBTQ+ inclusivity remains a frowned upon topic. As late as 2017, when Teresa shared about how she decided to come out in an interview with the Straits Times, she was particularly afraid of how other people would see her and how they would react. At home, she was worried that her parents in particular would take this news badly. However, they reassured her that all they want is for her to find somebody who would take care of her, whether that person is a boy or a girl. While Teresa's story has a happy ending, another close friend of mine is still facing challenges in broaching this topic with his parents. As an only son, he has been extremely filial to his parents and shares a very special bond with them. A number of years ago, he felt that he no longer wanted to hide his sexuality from his parents and wanted to be completely honest with them, as he has been with every other aspect of his life. This was not taken very well, unfortunately, with his mother feeling distraught that there was something wrong with her son, and even prays at the temple regularly with the hope that one day he will be normal again. I pray that one day his parents will accept him fully for who he is. Mr. Speaker, let me draw on what I see in the finance sector where I work. Many financial institutions encourage their employees to bring their true selves to work, because they believe that only then they can be truly engaged in what they do and fully develop their passions. Many banks see being open about being who you are can make for a more productive workforce. They have clear DEI, or diversity, equity, and inclusion talent policies. Incorporating DEI into business operations has been proven to benefit companies' performance because it encourages a wider range of views and opinions among staff. All these have clear, measurable impact and should equally apply to our country and economy too, where we place a very strong emphasis on developing everyone's potential. A survey by YouGov in May 2022 on behalf of LinkedIn shared that 75% of LGBTQ+ professionals indicated that it is important that they work at a company where they feel comfortable bringing their full selves to work. And 49% indicated that they will not work at a company that does not have LGBTQ+ family-friendly benefits. Similarly, a Deloitte survey of 600 members of the LGBTQ+ community across 12 countries showed that over 70% of its respondents are more inclined to remain with their current employer because of its approach to inclusiveness, while 37% of respondents indicate that they are actively considering changing employers to find one with a more inclusive culture. Every individual in Singapore should be able to contribute in their fullest capacity without fear of being discriminated against for who they are, be it over race, language, religion, sexual orientation, or gender identity. Only then can Singapore be truly a global, cosmopolitan, harmonious home that we can all be proud of. I have a male friend who married his partner of 7 years just before the pandemic in New York. The two men are in a loving relationship, but there's just one snag. My friend is an only son. When he's old and bedridden, he wants to know that he can trust someone to make difficult medical and legal decisions for him. All they hope for is that there is at least a jurisdiction out there that can give them society and legal guarantees that straight couples enjoy. That is why he married his partner, even though he knows that their marriage is not recognized in Singapore. I support the repeal of 377A and the constitutional amendment bills.
Ms. Seng Ling Ling.
Mr. Speaker, I rise to speak on the Penal Code and constitutional amendment bills as a mother, a community leader, a friend, in addition to my role as an elected legislator of this land. Since the proposed repeal of Section 377A was mentioned in the media and the public, I've received several written appeals from my Jalan Kayu residents to urge the government not to do so. These residents are mostly parents of young children and youth. As a mother, I can relate to their concerns. In October 2007, when the Parliament undertook a comprehensive review of our Penal Code since its major amendments in 1984, the public feedback on Section 377A was emotional. The Cabinet, after extensive public consultations and discussions, concluded at the end of the debate that Singapore society remained conservative and the majority preferred to uphold a stable society with traditional heterosexual family values while giving homosexuals the space to live their lives and contribute to society. As one who has been brought up in a traditional Asian family, I understand Singaporeans who uphold the construct of a family formed by marriage between a man and a woman. This is an important cornerstone of any society since the start and for the continuation of human history. Why then the need to repeal Section 377A now? The Minister for Home Affairs, Mr. Shanmugam, gave a detailed explanation. Section 377A was first introduced in 1938 when Singapore was still part of the Straits Settlement and under the colonial rules. The origin of the provisions of Section 377A stretch even further back to the Victorian times in the 1860s. Looking at the recent developments in other jurisdictions like India, India's Supreme Court struck down part of the Section 377 of their Indian Penal Code, which also criminalized gay sex. It went further to redefine marriage and familial relationship. As recent as in August this year, India's Supreme Court widened the definition of the family institution and ruled that familial relationships, I quote, can also take the form of domestic, unmarried partnerships and queer relationships, unquote. To me, what happened in India gives a glimpse of the implications of society norms when the judiciary branch of the government, which is the courts, instead of the legislative branch of the government, which is the parliament, began to interpret what are social norms because the legislative branch, that is the parliament, avoided dealing with the matter. As such, I think it is right for this Parliament of Singapore to debate and decide on the risk posed by recent constitutional challenges that our court is also facing in terms of Section 377A in our Penal Code, with the most recent one in just February this year in Tan Seng Kee versus Attorney General case. As I'm not a trained lawyer, I will not dwell further into the legality of this case, which Minister Shanmugam has also explained yesterday. Suffice to say that I'm of the view that this Parliament has the duty to set in place constitutional amendments to clarify our definitions of marriage and family. In this regard, I've also taken careful note as a community leader of the wider views, especially among our younger generations, whose views must also be valued. I will not repeat the studies and surveys that several of my fellow honourable parliamentarians has mentioned about the attitudes towards the repeal of Section 377A among our younger generations. I will share that in a Youth Network dialogue session, which I attended shortly after National Day rally this year, almost the full hall of youth audience between the age of 15 and 35 years old raised their hands in support of the repeal of Section 377A. On further dialogue, I learned that most youth are of the view that a law that will not be enforced is better off removed. I understand the views of the youth. But what touched me most in that session was a few young adults who shared that they regretted being too quick to judge and being insensitive in their teenage years when some peers struggled with their sexual identity in their puberty years. With more maturity now, they felt that they could have been more supportive. One even contacted me for opportunities in social service agencies to serve as a counselor for the homosexual individuals who may be in need, like how we would help any other individuals who are in need in Singapore. As a trusted friend of a few homosexual individuals, some of whom I've known since school days, I've heard their stories of life's challenges, of loss, and of regaining of hopes. What they taught me as a friend is the need for human kindness, compassion, and love to prevail over judgment and stigmatization. As we propose the repeal of Section 377A in our Penal Code and amend our Constitution for the Parliament of the day to be able to reflect our majority electorate's values on the definition of families in Singapore, let us do so with always a care for our fellow Singaporeans in heart, no matter how diverse we are. Mr. Speaker, I struggled with my speech for many months, like many honourable parliamentarians who have spoken up in these 2 days of debate. In the end, it was the reconciliation of my mind, of the duty I have as a parliamentarian, and my heart, which holds respect and care for people, that I accept the need for the repeal and the important amendments to our Constitution, which will leave space for us as a people to continue to forge understanding, reconciliation, and a future together. Thank you for allowing me to participate in this debate.
Mr. Derrigo.
Sir, during the Committee of Supply debate in March this year, I asked the government to clarify its position on the Court of Appeal's ruling on the constitutional challenge to Section 377A of the Penal Code, since it was last debated in 2007. Given proactive steps taken by government on stakeholder engagement, including Minister's explanation yesterday on the historical context of relevant laws, I fully understand the implication of the court's rulings and judgments. I welcome the government's clear explanation of the legal risk that the colonial era 377A faces and the potential domino effect on the other parts of our legislation and related policies. I accept Minister Shanmugam's interpretation on this issue. I also fully agree that it is the responsibility of our government and this House to address this issue head-on. We cannot cop out and pass this uncomfortable duty to the judiciary. Both Minister Masagos and Minister Shanmugam spoke on the perils of court-led decisions, where the US Supreme Court controversially reversed 50 years of federal abortion rights. US media there noted the chaos brought about by the court judgment to a great nation already split by deep political divide. Singapore cannot afford to take this path. As the debate on this topic can be divisive, I'm glad that our government has taken accountability and has taken steps to help us navigate this complex matter in an inclusive and transparent way where views from different segments of our society are heard. I too can attest to this process where after the National Day rally speech, we discussed this issue at Nee Soon's events with our grassroots leaders, residents, and religious organizations. We did so in a cool-headed manner, and I have to say, the discussions we had a lot of understanding and empathy. It was way calmer than I earlier expected, as this issue is an especially difficult one for all of us to speak on. This topic affects many in the community who are our friends, relatives, and colleagues from both gay and traditional families. While a majority of Singaporeans do not want to criminalize sex between gay men, residents I spoke to are concerned whether the repeal of 377A will lead to an erosion of the protection of marriage, family, and children, and if the underlying motives of past legal challenges go beyond mere removal of stigma and criminalization. I note that the Constitutional Amendment Bill, which safeguards the definition of marriage without tying the hands of future generations, is a balanced approach to allow government of the day to consider prevailing societal attitudes. On this premise, my community at Nee Soon welcomes PM Lee's and DPM Wong's assurance that the definition of marriage will not change under their watch, and the PAP's government stance of the traditional family as a basic building block of our society will be strengthened, while also respecting the dignity and place of gays in our community. On this point, it is my hope that on this basis, our government will continue to find ways to further strengthen the structure of marriage and family in our current policies. So, as we debate the repeal of 377A and the safeguards put in place, we should also be clear of any impact to the way of life as we know in Singapore and the measures necessary to guide the way forward. As the premise of the repeal of 377A is that what happens in private should not be criminalized, the concern of the community is that this could be incorrectly viewed as a signal for stronger public advocacy of gay relationships. We need to remember that the debate will not make this issue any less divisive. We should expect diverse and passionate views from different stakeholders in society to carry on after today. As such, we will need to continue to ensure a safe space for healthy and civil conversations, just as we did over the last many months, so that our society evolves peacefully. On this note, can Minister explain his thoughts on further mechanisms that government will put in place to promote genuine, healthy engagements? Will surveys be done regularly and discussed over national conversations? In some ways, this can guide the discourse moving forward, monitor fault lines, and potentially reduce harassment or discrimination of pro-gay groups or those who do not agree with them, especially in secular spaces such as schools and workplaces. Currently, some multinational companies offer family benefits to their gay staff, like those for traditional couples. Can the government explain if it supports such arrangements and its position if gay couples were to push for more workplace benefits? Sir, in Mandarin, 议长先生，关于377A 条文，过去几个月，我们在议顺的一些活动和基层领袖、居民和宗教团体都有讨论。他们提出的问题，我在英文演讲有谈到，希望得到解答。更重要的是，从这些谈话，我们可以看到，新加坡已经成熟，可以一起讨论敏感的话题，再找到平衡点。我认为这是新加坡独特的精神，希望我们可以继续求同存异，做出对社会更好的决定。So, in our Singapore pledge, we committed ourselves to build a democratic society based on justice and equality. For me, this process of stakeholder engagements leading to this debate has, I believe, enabled all of us to better understand what our pledge really means. Our government has demonstrated its even-handed approach, and the two bills placed before us are well-balanced and are steps forward in the right direction. It recognizes that there is a place for everyone, factoring the majority preferences and protecting the dignity of our gay community. We are all together better off. Singapore has always prided itself as a melting pot of cultures, races, and religions. In navigating and not avoiding this issue, we have grown together as a nation, and I'm confident that we can continue to find strength and harmony in diversity as we continue to write our Singapore story. I stand in support of this bill, these two bills. Thank you.
Ms. Rachel Long.
Thank you, Mr. Speaker. The announcement of the repeal of 377 has elicited much response from the ground. Many in this House shared and agree that this has been a divisive topic. Over the past 4 months, I've received emails and messages, met in person with residents and members of the public across age groups, who are supportive as well as those who are against the repeal. While most have been respectful in sharing their opinions, I've come to learn of the hostility some groups have carried against those who do not share their views. The vitriol in some manners of speech is of concern to me. Singapore understands the value of diplomacy and keeping peace with other nations. We do not have the option of being callous with our words or relationships. Diplomacy has been and continues to be key to our progress. However, it would be futile to work hard on external relationships if our internal relations are weak. A house divided against itself will not stand. Singapore cannot afford a society fractured by toxicity, with one group severing ties with the other simply because we hold different values and opinions. As Singapore progresses and continues to expose ourselves to global issues and movements, there will only be more opportunities for diverging options to arise in our society, and we must ready ourselves. We must work towards a society that can hold difficult conversations where we make room for disagreements and do not force people to a corner of hate. We need to allow many rooms for disagreement, but not disharmony. For this reason, Mr. Speaker, I wish to focus my speech on how we can shape Singapore conversations on contentious issues such as the repeal, with a heart set on peacemaking to close the space between us and find a way forward. Peace by domination and subjugation is not peace. One side prevailing at the expense of the other will break the social compact that is vital for us to be able to live in harmony. Once the compact is broken, repealing 377A will not be the only divisive issue. Some view the repeal as rending the moral fabric of society and vice versa. I take heart by the stated positions of a number of our respected religious leaders earlier in August. Then Archbishop, now Cardinal William Goh, spoke of the Roman Catholic Church's neutrality on the repeal, provided the Church continues to have the freedom to teach what it believes and practice what it teaches. Mufti Nazruddin Muhammad Nazar spoke of the complexity of the issue. He shared Islam's clear stance on sexuality and marriage, and at the same time, the need to respect differences and keep our society cohesive and intact. What we need to recognize is that the moral and social fabric of any society are intricately intertwined. One risks being torn as a consequence of the rending of the other. As such, I commend our government for seeking to protect both the moral and social fabric of this nation through the proposed bills. After all, problems are solved in the middle, not at the extremes. Finding a way forward does not mean we have to hold on to unenforced laws like 377A. Nor does it mean we have to redefine marriage and consequently family. Since our families form the foundation of the moral and social fabric of Singapore, we must protect the definition of marriage to avoid more division amongst our people as lines get blurred. Finding a way forward does mean that people groups that fall outside the norms of a traditional family are still to be embraced and supported. Whether single parents, singles, widows, widowers, or homosexual family members and friends. As a Member of Parliament, I represent the aspirations of residents from traditional and non-traditional family units, and also the rights of my constituents, regardless of their sexual orientation. I hope the decriminalization of gay sex will bring relief for those who have experienced discrimination. At the same time, those who are heterosexual should also not have to live in fear or be discriminated in their workplaces, schools, and communities because they stand neutral or express pro-traditional family views. It has brought distress to some parents to hear that terms ranging from cancel them, bigots, to homophobic derogatory names are being used in our classrooms against students who do not share the same views on this topic, forcing others into silence. No one should attack the other, and no one should fear being cancelled for holding and expressing pro-homosexual, pro-traditional family views, or neutral views. We cannot allow coercion to infringe upon an individual's right to decide on matters of conscience and conviction. This is a right that we must protect through legislation as an open, multi-religious, and multi-ethnic society. Wisdom is found in the ability to get along with others. Just as family members differ from each other, yet still share our lives together, can we as Singaporeans define our relational compact to be one of a wider brother or sisterhood? We can remain honoring of others while disagreeing, respectful without conforming. Singapore has worked hard to create and build models that have worked well for us, economically, socially, and religiously, precisely because we are a pluralistic society. This has been our strength, not a weakness. I'm hopeful that we can do the same in the space of affirming heterosexual marriage and family culture, while creating safe social spaces for gay persons. On the personal front, my feet are firmly rooted in my faith, and my arms are wide open. Wide open especially to people who believe differently from me. It is this rootedness that allows me to love and walk alongside those different from me, and to stay interested in their lanes and their realities. On the repeal, let us remember that our sexual identity, while being an important aspect of our identity, is not the sum total of who we are. If we choose to go deeper to our fuller human identity, we will perhaps find connections that will help us acknowledge and understand each other in our common humanity. Mr. Speaker, my hope is for us to be intentional in sieving out divisive voices in the midst of deep disagreements. Let us not give in to discord, nor give up on unity, but give our best to our nation. May we then realize our commonalities, close the space between us, and together discover the Singapore forward. Thank you.
Order. I propose to take a break now. I suspend the sitting and we'll take the chair at 4:25 p.m. Order. Order.
Order.
Item 1, resumption of debate on the Constitution of the Republic of Singapore, Amendment Number 3, Bill, second reading.
Minister Shanmugam.
Thank you, Madam Speaker. I thank Madam Deputy Speaker. I thank the members who have spoken up in support of the bills. Many have, or most have expressed support for the repeal of Section 377A. I will deal with questions raised by members on our approach towards cancel culture, past Section 377A convictions, keeping sex identification in NRICs and passports, Article 156, and one or two other issues. Mr. Zulkarnain asked for any update on the government's plans to deal with cancel culture and whether there will be any consultation and feedback process. My Ministry of Law, is looking at measures to deal with the harm caused by cancel culture, cancel campaigns online. People really ought to be free to stand by their beliefs, express their views with due respect for the feelings of others without fearing being, quote unquote, cancelled. Many religious groups and organizations in particular are very concerned about this. Many church groups have spoken with us. Their experience is that when they express their views, they are shouted down and they feel bullied. Children in schools also feel this, and this is not right. I have said that we will try and do something about this. We are studying the matter. We are consulting different groups as part of our review. We want to try and strike a right balance. It's not an easy area to deal with or legislate on. We will give more details when we get a sense of what is doable. Mr. Louis Sung asked whether there are any individuals with existing conviction records under Section 377A and how these records will be dealt with. There are some individuals with convictions under 377A. Most of these cases involved non-consenting victims or acts against minors or sexual acts committed in public. These acts continue to be offenses even after the repeal of or even after any repeal of Section 377A, and we do take a serious view of them. Criminal records for offenses are dealt with under the framework in the Registration of Criminals Act, and within that framework, people can apply to have their convictions spent. Some of these offenses have become automatically spent. Automatic expiry takes place after a period of time for specific offenses and where the criteria are met. Persons who are disqualified from having their convictions automatically spent can apply to the police for the record to be considered spent or rendered spent. But where egregious acts were committed, like non-consensual acts or sexual acts against minors, the records are unlikely to be treated as spent. There are a small number of individuals who were convicted between 1988 and 2007 for consensual private homosexual acts between adults. I've instructed my ministry to consider how the records of these persons can be rendered spent proactively. Mr. Lim Biao Chuan said that he hopes that the government will not allow individuals to remove their registered sex from their NRIC or passport. The short answer is that there is no such plan. Ms. Lim suggested that there is no real need for Articles 156(1) and 2, since the Constitution already vests legislative power in the legislature and the executive authority in the government. Let me explain. It's a fairly basic point. Let's take Section 377A as an example. It's a law made in the exercise of legislative power by Parliament. 377A has been challenged as being in breach of the Constitution. Ms. Lim agrees that 377A could be unconstitutional. And the presence of Article 38 in the Constitution will not help if 377A is in fact unconstitutional. To put it another way, the fact that Parliament can pass laws and that Article 38 gives that power does not automatically mean that all such laws cannot be challenged. They can be challenged, for example, if they are contrary to the Constitution. And Article 156 is structured to give effect to protect laws and policies based on the heterosexual definition of marriage. So Articles 156(1) and 2 have been drafted in to give effect to this principle, to protect the laws and policies based on that definition, and to make it clear that passing laws and having policies based on the current definition of marriage are constitutionally valid. And they give context to Articles 156(3) and 4. We have been advised by AGC that Articles 156(1) and 2 could be relevant if there are questions raised as to whether regulating marriage and so on are constitutionally valid purposes and considerations for action by the legislature and government. Thus, Articles 156(1) and 2 have been enacted to make it clear that the legislature can exercise its legislative power to define, regulate, protect, safeguard, support, foster, and promote marriage. Similarly, the government and public bodies can exercise their executive authority to achieve these ends. Mr. Murali Pillai asked, why is it necessary for Article 156(3) and 4 to exclude the whole of Part 4 instead of just Article 12, instead of just a few articles? Thank you. Let's look at Article 156(3)(a) first. This protects the heterosexual definition of marriage itself from invalidation by Part 4. We need to exclude the whole of Part 4 because we cannot predict what possible arguments might be made against this definition in the future. With 377A, we have seen how the arguments in our courts progressed from equal protection under Article 12 to asserting that sexual conduct is a form of liberty protected by Article 9 or a form of expression protected by Article 14. Some of these alternative arguments have been accepted by courts in other countries, and it's possible that additional creative arguments could be made about the heterosexual definition of marriage. For example, could marriage be a form of association that is protected by Article 14? Members may think it is a little outside of the orthodox interpretation today, but can you rule it out? Thus, if we want to properly protect the heterosexual definition of marriage from court challenge, we have to exclude the whole of Part 4. But it's not a carte blanche. What is protected is quite precise. It's the heterosexual definition of marriage. That is because, just as we have been clear about repealing 377A, we took a clear position. We are equally clear, and this government is very clear, that we will protect the heterosexual marriage as a key institution in our society. And that is why the Constitution is being amended. But, let me digress and say, as we say all this, and as we listen to the speeches by MPs on families, let's also not forget, let's also acknowledge that LGBT persons also have and come from families. They have parents, siblings, grandparents, nieces, nephews, aunties, uncles, close friends, and much more. So families are not exclusive to non-LGBT persons. So let's remember and acknowledge that these things are not binary. But back to Article 156. If Parliament tries to enact, say, for example, apartheid marriage laws or impose other outlandish definitions of marriage, those laws would not be protected. Because if you look at Articles 156(3)(b) and 4, the operating provisions, they protect the ability of Parliament and government to make the laws and policies. The protection, the shield is strong, but what is shielded, we have sought to make it quite precise. If the government tries to give benefits to married couples, for example, say with the surname Tan, Article 156 will only protect the part of the policy that relates to married couples. Government will still have to justify why giving benefits to only people with a certain surname is a relevant consideration, and I think lawyers will understand it will probably not be accepted as a relevant consideration. Nor will the government be able to take measures that are absolutely prohibited under Part 4, for example, slavery. If such a measure is taken, the challenge will not be that it is based on the heterosexual definition of marriage or some other basis. It will be on the basis that these measures are not allowed on any basis. So to directly answer Mr. Murali Pillai, no, Article 156 does not enable the government to banish anyone, as the term is conventionally understood today. Why do I say that? Let me give an example. It will be a nice constitutional question if, for example, a same-sex couple were to argue that since Singapore does not recognize same-sex marriages, they had no choice but to emigrate, and that is effectively a banishment, and that this government's policy in not recognizing same-sex marriages is therefore in breach of Article 13, which precludes banishment. Now, so you can see that a careful person will want to think about the different possibilities of arguments and then make sure that the drafting covers the different possibilities. So we do not believe that the government's policies and laws are in breach of Article 13, or for that matter, any other article in the Constitution. But members can see that creative arguments can be made. And so if you want to be clear that you want to protect marriage and keep it within the province of Parliament, then you need to make sure that your drafting is accurate. So that is why we have had to draft Article 156 in the way it has been worded. In the case of executive actions, common law judicial review under administrative law principles will generally still apply. The application of those principles must, however, take Article 156 into account. For example, with Article 156, acting to promote marriage would not be an unlawful purpose or an irrelevant consideration. But otherwise, admin law principles can and will still apply. Ms. Lim and Ms. Hating Roo say that judicial review under Part 4 should be fully available without restriction. Article 156 takes two specific issues out from the court's province and keeps them entirely within the province of the elected branches. One, the heterosexual definition of marriage, and two, the ability of Parliament and government to make laws and policies based on this definition. The government believes that this is necessary for the reasons I have explained. Parliament and the elected government should deal with these questions and try and strike the right balance on these complex and delicate social issues. Ms. Lim's and Ms. Hayes' position would mean that they accept that the courts can strike down the heterosexual definition of marriage, or to curtail the ability of Parliament and government to make laws and policies based on this definition, and for society to live with the consequences after that. This, then, is the choice before the House today, whether we decide to have the certainty that Parliament will decide on issues of marriage, or whether we want to leave this to the courts and live with the potential threat of unconstitutionality and have that change imposed on our society, as has happened in other countries. Let me now turn to the Workers' Party's position on 377A. Mr. Pratam Singh, as leader of the opposition, says that the Workers' Party does not take a position on the matter. Thus, as a party, the Workers' Party has no official position. It does not support the repeal of 377A. It doesn't quite oppose either. It also does not support the constitutional amendments to protect marriage. From their speeches, Mr. Singh, Ms. Lim, for example, support the repeal. And while Mr. Singh supports the constitutional amendments, Ms. Lim and Ms. Hating Roo do not support the constitutional amendments. Mr. Dennis Tan and Mr. Gerald Giam are against the repeal, but support the constitutional amendments. Mr. Leon Pereira is for the repeal somewhat more enthusiastically than his leader, and as for the constitutional amendments, he takes a divergent position from his chairman, Ms. Lim. So the Workers' Party had a debate among themselves. They debated and discussed, but didn't decide on a party position. And so the question is, if this is how one decides, how will such a team function if they are in charge? Mr. Singh said his lifting the whip on Workers' Party MPs was democratic, so as to allow for a full and honest representation of all views. That explanation is factually untrue. Every MP must know that. So it does no credit to this House to say these things. The Workers' Party MPs could have made all the speeches they made, even with the whip in place. MPs are always entitled to state their honest views. They can agree, they can disagree, they can say what they think. You can express your views, whatever they are, without having to lift the whip. I repeat that. The whip does not and has not prevented MPs from speaking their minds. MPs have always been free to express what their constituents think. The whip is relevant for voting, not speaking, and the whip sets out the party's position. In moving the bills, Minister Masagos and I took pains to lay out both sides of the issue. The PAP MPs speaking on the issue too have reflected the concerns, the fears and pain of the many individuals they have spoken with. These include views of Singaporeans from different religious groups, LGBT groups, and others. So do not be mistaken. Views on all sides can and have been and must be fully ventilated, and they have been ventilated by PAP MPs. As I said earlier, the whip is imposed to set out the party's position as a whole. In our Westminster parliamentary system, parties must have a view on important questions that come before Parliament. They need to be honest in this House, say what they think is good for Singapore, and be accountable to the electorate for their decisions. The real point is that the WP, as a party, does not want to take a stand on this matter. It does not want to be seen as supporting the repeal. At the same time, it also does not want to be seen as opposing the repeal. That way, it hopes to be all things to all men and not too much of anything to anyone. Members may know the second line was said in respect of a well-known person. In my remarks yesterday, I reminded members there are two reasons for repealing Section 377A. First, it is the right thing to do, because there are no public concerns that justify private consensual sex between men being a crime. Some disagree with that. They think that the law should be retained as a matter of conscience. I mentioned yesterday that I accept that. We understand and respect these views. These are seriously held views by honest, sincere people, including in this House. They have thought about it, have decided that for reasons of conscience and often of personal faith, they cannot agree to the repeal. But I also outlined a second reason to repeal Section 377A, the significant legal risk of it being struck down by the courts if we were to leave 377A alone, and the significant negative and disruptive consequences for Singaporeans and Singapore if that were to happen. That is a policy question, a question that requires us to consider what is in Singapore's interests. From the debate, the following points are clear and are not in question, and the WP does not question them. 1, 377A is at risk of being struck out for being unconstitutional. 2, If 377A is struck out, then there is a further risk that the definition of marriage could be challenged as well. 3, and that then means that there are risks that our housing, education, media content policies, and multiple other policies could all be challenged. No one has questioned these risks in this House. The WP understands this. There are 4 lawyers among them in this House, including Ms. Lim, who has agreed that the legal risks to 377A exist. Given that, then what does the WP as a party propose? If you don't want to repeal 377A and also do not want to support strengthening marriage, which we have proposed, the position with 377A is like a train approaching. The question is whether we have the courage to act or rather dive for cover to protect yourself and leave society to face the train wreck. I emphasized this quite strongly yesterday. Given the risks, we have a responsibility to do our duty as parliamentarians, to take a position, to deal squarely with the problem and not abdicate our duty. To say the party has no position allows the WP MPs to make speeches supporting all sides without having to make a decision and be held responsible for that decision. That's not true democracy. It is better described as wanting to speak without taking responsibility. In the context of our debate, their position will mean that they will leave the decision to the courts and let Singaporeans face the negative consequences, including perpetuating differences and polarizing our society further. If we leave this matter to the courts, because the courts can only make binary decisions, as we have seen happen elsewhere. And if the WP truly believes that these sensitive matters ought to be decided by the court, never mind the consequences, including further dividing us in endless rounds of litigation, then they should be honest and say so in this House. The only reason we can have a decision in Parliament is because the PAP has its whip in place. When you stand up and speak at length about the pain and suffering of the LGBT community, then I think one can ask, why don't you take a clear stand and support the repeal? Or if you believe otherwise, take a stand, oppose the repeal as a party. As I say this, sir, let me tell members, the issue of conscience, which is real, is quite different from the issue of policy. I have focused on the policy issue, and I think it is not too much to ask that a clear stand be taken on policy issues. Let me end by quoting Winston Churchill. They are decided only to be undecided, resolved only to be irresolute. So this government has consulted widely and has come to a position. We believe that our policy offers a way forward. It balances the different views, maintains our social cohesion, keeps us together. The Prime Minister and Deputy Prime Minister Wong have stated clearly that they will maintain this position. On this difficult matter, we will do our duty and take responsibility for holding society together. Thank you, Madam Deputy Speaker.
Mr. Masagos Zulkifli.
Madam Deputy Speaker, I thank members for putting forth their perspectives and reasoning on these very important debates. In this House, members have reflected the complexity of the issue and the diversity of our stakeholders, something a court process will not achieve. Members have shown why Parliament, rather than the courts, is the right forum to debate difficult social issues. We have explained clearly why we must act without delay. inaction will leave open the significant legal risk that the court will, at some point in the future, rule Section 377A unconstitutional. Parliament has a duty to act. Let me turn to what we all need to do to keep Singapore united after we have debated and then voted on these bills. Many members touched on this in your speeches. Some have voiced the concern of Singapore going down a slippery slope after the repeal. Some touch on support for families with single parents. Others ask about the posture in educational institutions and express concerns on religious freedom. Mr. Alec Yam, Mr. Sharil, and Mr. Abdul Samad have asked for assurance that the repeal would not result in a change in social norms. Mr. Derek Goh asked about the use of surveys and engagements. It is indeed the intention of the government that there should not be a change in social norms following the repeal. This is precisely what Article 156 is intended to achieve. I explained in my speech yesterday that many different practices and policies that support society's notion of children within a marriage between a man and a woman. On surveys, while they can help facilitate conversations and potentially reduce discrimination, we recognize that a single or a series of questions would not fully capture such a complex and emotive matter. It also depends on the survey's sampling method, whether it is representative, and when it was conducted. We have engaged extensively on this matter. There are ongoing efforts to facilitate conversations and civil dialogue. Mr. Pritam Singh, Mr. Mark Che, Mr. Louis Ng said that there should be support for other families such as single unwed parents. My opening speech explained our approach. We make a distinction between incentives and supports. Benefits intended to support a child's development and caregiving are given to children of single unwed parents and of married parents equally. These include healthcare and education subsidies, the government's first step grants, and co-matching of the child development account, as well as the government-paid maternity leave to unwed working mothers to care for their infants. Let me now turn to educational institutions. Ms. Janet Ang and Mr. Fahmi have asked about sexuality education in public and private schools and the madrasas. Dr. Tan Yaswam said students should be taught based on evidence. Mr. Henry Quek commented that school leaders should take a clear, objective stance. Mr. Mark Che asked how we prepare students to be more understanding and emphatic. Mr. Lim Biao Chuan also asked about international schools that compel staff or students to participate in gay community projects, even if they do not subscribe to the same lifestyle. I explained in my opening speech that our education policies and curriculum remain anchored on Singapore's prevailing family values and social norms, which most Singaporeans want to uphold. These include the family as the cornerstone of our social fabric and marriage between a man and a woman. In our schools, all students learn and practice values such as mutual understanding, respect, and empathy for everyone. They will also understand that issues can have multiple perspectives and are taught to listen to each other's points of views, understand the perspective of others, and learn to interact and engage respectfully with each other, even if their views differ. The sexuality education curriculum in MOE schools respects the primary role of parents and reflects the national posture on the heterosexual family as a basic unit of society. The curriculum remains secular and based on research and evidence. It is focused on age appropriateness and the developmental needs of the child when touching on topics such as homosexuality. In madrasas, sexuality education is part of the education curriculum. and included in specially curated programs. Madrasas are also equipped with trained asatiza and teachers to address sexuality issues. Counselors are available should students need further advice and support. MUIS is in regular consultation and collaboration with the madrasa to further enhance the sexuality education curriculum for students. Teachers will also be equipped and updated on the current discourse on the matter to advise and guide students on matters related to sexuality according to the teachings and traditions of the religion. For international schools, MOE does not regulate the curriculum. That said, as the schools operate in Singapore, they should respect our social norms and values. They must also be careful not to cross the line into advocacy on issues in Singapore that could be socially divisive, such as how sexual orientation are handled in laws and public policy. These are matters for Singaporeans to discuss and decide. Mr. Louis Ng asked how LGBT students struggling with family and mental health issues are supported. Mr. Zulkarnain also asked how teachers and educators are supported. Our schools have a system of support for students with issues concerning their well-being, including on sexuality. Teachers will listen to students objectively to facilitate support and not discount, disregard, or judge their views. They assure confidentiality, but explain to students that the disclosed information has to be shared with the appropriate key school personnel to assist students in managing their concerns. Teachers also consult the school leader and lead school counselor who will further manage these cases with the school counselor providing targeted support for the students' concerns. Where required, schools will, with parents' consent, refer students to professionals and relevant authorities to provide counseling support and appropriate intervention. MOE's focus is on the students' well-being. Students must remain a common and safe space for all students, regardless of their background. We have a duty to care for every student. For students with sexuality issues, our focus is likewise to provide them with a conducive learning environment and the necessary support to ensure their overall well-being. As sexuality issues are complex, schools work with these students and their families sensitively. Mr. Zulkarnain asked where families can seek help. Family service centers offer family counseling and can also assist if family relations are strained because one of them has sexuality concerns. Lastly, members, Mr. Christopher D'Souza, Mr. Zulkarnain, Mr. Fahmi, and Mr. Lim Bao Chan, Mr. Daryl David, Ms. Janet Ang, and Mr. Alex Yam have spoken about religious freedom. I would like to make clear the government's position. First, Article 156 will provide further protection for the definition of marriage as between a man and a woman. There are no plans to change this definition to include same-sex marriages. Religious leaders or any licensed solemnizer for that matter cannot solemnize a same-sex couple. This is against the law. Second, religious freedom is protected in Article 15 of the Constitution. Every person has the right to profess, propagate, and practice his or her own religion, subject to public order, health, and morality. Every religious group has the right to manage its own religious affairs. One can still preach on the pulpit their beliefs about homosexuality or family, even if others might disagree. But no one should incite violence or hate towards others. This is against the law, and is not the society we want to become. This is regardless of whether the comments are made in public, online, or in your private space. Religious organizations, as owners of their premises at places of worship, have the discretion to refuse same-sex solemnizations or weddings to be held on their premises. There is no law which prohibits them from treating same-sex couples differently from opposite-sex couples when exercising such rights. Religious organizations may support those who are struggling or have issues with their sexuality, including through prayers and counseling, as long as consent is obtained and criminal thresholds of harm are not crossed. Third, in exercising religious freedom, we must understand that we are also members of a plural society. We must graciously accommodate those who have different values from us. Gay people are members of our society and have access to the same opportunities and social support as other Singaporeans. Social service agencies provide secular services to the community. Some SSAs are set up by or affiliated to religious organizations. All SSAs, regardless of their religious affiliations, serve all clients, including gay persons. Social service professionals are continually trained to be sensitive to the diverse needs of their clients. Fourth, on employment, workplace, and businesses. We do not tolerate discrimination at the workplace. Employees are protected against discrimination under the tripartite guidelines for fair employment practices. These guidelines require employers to make employment decisions based on merit and not factors irrelevant to the job. For religious organizations, understandably, the potential employee's religion and values would be a relevant consideration for certain roles. Mr. Derek Goh inquired about staff benefits offered by companies to gay couples. The government generally does not interfere in how a private business operates. However, private businesses must respect that their own staff have a right to their personal beliefs. They also cannot cross the line into advocacy on issues in Singapore that are socially divisive, which includes issues on homosexuality. These are matters only for Singaporeans to discuss and decide. At our workplaces, employees should not feel compelled to support causes or participate in activities that do not align with their beliefs. The TGFEP is clear that an employee's support or non-support of causes is not relevant to job performance, cannot be used in employment decisions and performance evaluation. Lastly, we should keep the marketplace free from the polarizing contestation of values. In a free and open economy, when abundance of choice, businesses can decide what events are allowed on their premises. However, while businesses make their own commercial judgments with regard to their prospective customers, they should do so in a sensitive and respectful manner. Nonetheless, I urge everyone not to use commerce as a platform to display the conviction of their beliefs. In the spirit of mutual respect, I hope businesses and prospective customers can strive to be gracious and adopt the approach of live and let live. Madam Deputy, Mr. Speaker, sir, for complex issues such as these, we must exercise leadership to make difficult decisions that is best for our society, even if it does not satisfy everyone's wishes. We are a secular government, and while each of us as individuals may have our religious convictions, we take care to ensure that when we make decisions for the whole country, we apply secular, universal values and not individual religious beliefs. Mr. Dennis Tan, Mr. Gerald Giam, and Mr. Faisal Manap indicated that they will not support the repeal because of their religious values. Yet they do not offer any solution on how we can keep society united and cohesive. If Section 377A is found to be unconstitutional, is there a solution to accept a decision by the courts? What would be the implications? If so, why not vote for the repeal now? Ms. Hazel Phua says PSP wants the definition of marriage to be decided by national referendum rather than by Parliament. the government has explained why we are not proposing to hold referendum on this issue, but let me explain again. Our Constitution sets a very high bar for the holding of referenda. A referendum is required when sovereignty or the command of our armed forces and police is at stake. We have only one referendum in our history on merger with Malaysia. We should be very careful about elevating any matter to this level, saying it is equivalent to an issue on sovereignty. It's the duty of elected MPs to consult, to discuss, and to come to a decision, even and perhaps especially for difficult and polarizing social issues. The PSP says that we should not allow Parliament to decide, but instead let the definition of marriage be decided by national referendum. This might seem seductive, but let's call it what it is. It's an attempt to avoid taking a position as parliamentarians, as elected representatives of the people. Even if a referendum is held, which side will the PSP be on? Will the PSP try to bring people together or stay silent on where it stands on heterosexual marriage, as it's doing in this debate? Also, will the referendum settle this issue once and for all? May I remind members and the PSP what happened in the UK with Brexit? Both sides campaigned vigorously and bitterly. It created an entrenched, polarized identities. Brexit was eventually approved in a referendum with the slimmest of margins, and people continued to campaign for a second referendum. In the process, the credibility of the British government was severely damaged. Indeed, it has yet to recover. Despite being government, the Tories were split on Brexit. The leadership, rather than uniting around a single position, allowed their MPs and even their ministers to take different views. A government unable to act cannot govern. Let us not look for politically easy options and cite referendum as an easy solution, just so that a decision does not have to be made in Parliament. In any case, even if the PSP wants a referendum, does it or does it not support the constitutional amendments? They seem to be against it. It then leaves the courts to decide on heterosexual marriage. I've explained why this is not ideal. In any case, PSP seems to be against the constitutional amendments. I've explained why that is not good for Singapore. Mr. Speaker, governing requires us to bring people with different perspectives together, to ensure that various segments do not push for a maximalist position which would impinge on others, and pave the way forward. Especially, we should not adopt positions just because it coincides with our own religious beliefs. Indeed, everyone in Singapore cannot expect their maximalist position to be realized because Singapore is a vastly diverse society. Singapore has progressed because everyone understands this and have been accommodating of each other. This applies to governance. To be able to faithfully discharge our duties as leaders, we cannot make decisions that affect our fellow citizens based on personal religious beliefs. Instead, I hope we understand the principles of our religions in making decisions that affect others. That's what the Malay Muslim leaders we engaged were able to do after numerous engagements. They went beyond their own perspectives and assessed what is good for the community, Singapore, and Singaporeans. They accepted why these changes need to be made. I hope all members of this House can do so too and support the repeal of Section 377A together with the proposed amendments to the Constitution. Let me conclude. As a society, we cannot lose sight of mutual respect when we engage with one another and must endeavor to listen, to those who disagree with us. We must not destroy their social or economic standing. We should not denigrate others. This applies to all sides in every debate. We should consistently exercise responsibility, restraint, and sensitivity to one another, both online and in person. The work of staying united as one Singapore is what lies ahead of us, even as the debate on these two bills conclude. Mr. Speaker, this debate proves that this House is indeed the right forum for issues and policies that are complex and require political judgment. It's an example of Parliament stepping up to do its duty. It's a responsible government that has balanced the views expressed by members and stakeholders and has shown the viable way forward. We did not deflect the matter to the court, nor kick the can down the road. This is the strength of our system in Singapore, when each branch, the legislature, executive, and judiciary, does its part to its fullest and does it well, and does what is right for Singapore and Singaporeans. We have had a robust debate with the passing of the two bills, the repeal of Section 377A and the introduction of the constitutional amendment. We have created space for society to deliberate on social issues within the political process and not through a legal route which is zero-sum in nature. It's time to come together and move forward. Preserve the peace and stability that our society has fought hard for and forge ahead. United, not divided, so that we can achieve progress as a nation for many more years to come. Thank you.
Mr. Pridham Singh.
Thank you, Mr. Speaker. I think the Minister, I refer to Minister Shanmugam, has mischaracterized my speech somewhat. What I said was specific to the party position in 2019, and here there was a context. The party position, as I mentioned, was varied and divided, with no consensus as to whether 377A should be repealed, and as I said, somewhat similar to Singapore society. I lifted the whip and did not fetter the voting rights of MPs. I did not say speaking rights. I did not fetter the voting rights of MPs. This is consistent with the party position. What has been the result arising from this debate? 6 for a repeal of 377A, 3 against for reasons of conscience. The party position has now been established by way of a majority in Parliament. On the Constitution, 7-4, 2 abstentions for the reasons the members mentioned. All the Workers' Party MPs, apart from Mr. Faisal Manap, who is down with COVID-19, put their personal positions on the record. And in my view, they behaved like a loyal opposition, not loyal to the PAP, but loyal to Singaporeans, knowing the position of Singaporeans outside of this House. I have 2 clarifications for the Minister, the Speaker. The first, my question pertains to an understanding of how and why the PAP chooses to lift the whip for some bills and not others. And I raise this because the Minister raised it in his closing address. DPM Wong announced that the PAP did not lift the whip for this debate because 377A is a matter of public policy. The Prime Minister in his National Day address this year said that not everyone is equally accepting of homosexuality, and there were considerable reservations within certain religious groups. Now, for the Human Organ Transplant Bill of 2009, the PAP lifted the whip so that MPs could vote based on their religious and ethical beliefs. The first generation of PAP leaders under Lee Kuan Yew did the same with the Abortion Bill of 1969, where Mr. Lee Kuan Yew himself rose to deliver a speech, but was absent when it came to voting. If I follow Minister's reasoning, would it be correct to say Mr. Lee Kuan Yew was abdicating his responsibilities? Now, there would be compelling reasons to suggest that for both these bills, public policy could have been deployed as a reason not to lift the whip. But the PAP lifted it anyway. Can the Minister please clarify the consistency or lack of consistency with regard to lifting the whip? My second question pertains to implications of the constitutional amendments for the LGBTQ+ community in the political context. With these amendments, the effect would be that the courts are not the correct forum to determine questions of housing policy and same-sex marriage, for example. At the 2011 general elections some 11 years ago, the sexual orientation of an opposition candidate came into the spotlight, with the PAP asking the Singapore Democratic Party to, I quote, come out of the closet, unquote. And the PAP statement on this issue pursued an innuendo that made an allusion to pedophilia. In view of the speeches made by PAP MPs over the last 2 days and the call for any change on the definition of marriage to be a political question, can I confirm the PAP's position with regard to LGBTQ+ candidates standing in general elections? Thank you.
Thank you, Mr. Speaker, sir. Now, Mr. Singh mentioned democracy. He said that in the pursuit of democracy, he will lift the whip. If he now says that's not so, then he can state that for the record. He said, we are more democratic, we lift the whip, and I just wanted to point out, let us just be accurate. People can speak their minds even with the whip imposed. And when Mr. Singh says the whip will not be imposed on his MPs, he is referring to voting positions. He is referring to a party position that when he came into chambers here yesterday, the party did not have a position. That is what we are talking about. And his MPs spoke on both sides. Party did not have a position. It's not a question of totaling up the numbers at the end of the day. It's a question of coming up front and saying, this is our position as a party, even though individuals have their different views and they will speak about them. That is the point I was addressing. Now, when will a whip be lifted and when will a whip not be lifted? I made it clear in this case why is the whip being imposed. It is because it is a policy question with serious consequences for Singaporeans. If we do not repeal Section 377A, then we are saying we will not do what we have to do, and we will pass on the buck to the courts. That's an abdication of responsibility as parliamentarians. In such a situation, lifting the whip is not acceptable for the PAP because societal interests are at stake. But where it's purely matters of conscience, and you don't quite see such a significant issue for society as a whole, where the very institution of marriage and all your housing policies and your education policies and your rules on the structure and basic content of society can change overnight, and where societies get rent asunder by cultural wars. Those are the risks we are talking about. And do we duck and say, well, we don't have a position? So you're leaving it to the courts. Abortion is quite different in that it was a matter of individual conscience, at least at that point in time. I think today the issue is well settled, in Singapore at least, unlike in some other countries. But at that time, it was a matter that raised very serious personal concerns. I mean, people would know the arguments in Ireland much more recently. So I wasn't in the House at that point in time, and I don't think we should draw conclusions from the fact that one or another member was present or was not present. But I would be careful if I were Mr. Singh to bring Mr. Lee Kuan Yew into this and suggest that he somehow acted dishonorably. Now, if Mr. Singh can remind me on your second question.
It was about the LGBTQ question vis-a-vis whether they would, the PAP's position as to whether the LGBTQ community would not be victim of some personal attacks.
I think Mr. Singh mentioned pedophilia. Again, I don't recall the facts, so I can only answer in hypotheticals. I think if a pedophile was standing for elections, I'm surprised Mr. Singh would advocate that cause. Thank you, sir.
Mr. Pritam Singh.
Mr. Speaker, let me take up the last point. Before that, sorry, the point of abdication and suggesting that I'm saying Mr. Lee Kuan Yew was dishonorable. I never used those words. I think I made the point in the context of the question that I put to Minister. On the issue of pedophilia, let me share the specific statement that the PAP made, which led me to make that point. This was the statement that was released by the PAP. What is his agenda? A video has been posted on the internet showing Vincent Vijay Singha participating at a forum which discussed the promotion of the gay cause in Singapore. I don't think there's a problem with that statement. And thereafter it says, the discussion at the forum also touched on sex with boys and whether the age of consent for boys should be 14 years of age. The innuendo, I think, is clear. In the video, Mr. Vijay Singha was introduced as being from the SDP. In addition to other comments, Vijay Singha stated, I think the gay community has to rally ourselves. Perhaps one outcome of today's forum would be for those of us who are interested to come together to further consider how we can address the 377 issue, as well as further rights issues in relation to gays and lesbians. Now, I don't have any issue with the PAP coming up and saying, look, what is the political agenda of a candidate? But what is the relevance of that point on sex with boys? If not to cast aspersions on the candidate himself and to suggest that, did he make that point? Was this a forum where this was the only issue that was discussed? So that was intentionally included. That's my view of the statement.
Mr. Speaker, sir, I hope we don't have to go into an extended discussion on this. Mr. Singh started out the second question by saying that pedophilia was talked about. Now, let me make it clear to him. If there is a candidate who is standing for elections, whether for the PAP, and I hope the PAP will never field such a candidate, or for the Workers' Party or SDP, and if there is a suggestion of pedophilia, I will certainly speak about it. And I'm sure all right-thinking Singaporeans will speak about it and will say it is not acceptable. So I don't quite know the precise context, but as I said in my speech, sexual offenses against minors continue to remain serious offenses, and we take a very serious view. And I hope Mr. Singh is not suggesting that pedophiles stand for elections and we do not need to talk about it. As to whether there are broader innuendos, I think let's get to the point, Mr. Singh. As the Workers' Party trooped into Parliament yesterday, there was one point, and that point is, Mr. Singh, sir, as leader of the opposition, was not prepared for his party to take a position. That is what we are talking about, not about an election held in 2011. We are talking about 2022. What is our position on 377A, and whether we come here prepared to take a position or we are abdicating. I think I've made my points. We leave it to Singaporeans to judge.
Mr. Singh.
Likewise, Mr. Speaker, I think I've made my point with regard to what Minister has said, but the issue wasn't about pedophilia, and I agree with him. I don't think anybody in Singapore would be thrilled to have a pedophilia as a person who is a pedophiliac standing for elections. But the question I asked was, what is the PAP's position with regard to LGBTQ plus candidates standing in general elections? I don't think a question has been answered.
It appears to me that, as usual, Mr. Singh wants to move the goalposts and start an entirely new debate about who can and who will stand for elections. I'm not the Prime Minister or the Secretary General of the party, but my personal view is that anyone who is not a criminal and who is of good character and of sound mind and who can work for the residents ought to be able to stand for elections. In all of this, in a democracy, it also depends on how people are perceived and accepted in society. All of these are relevant considerations. One has got to look at individual candidates. But Mr. Singh started out by talking about pedophilia. I'm sure the records Hansard will show that. And that is why I answered, because I was shocked that he would even ask that question. Thank you.
Mr. Singh.
Indeed, Mr. Speaker, the record will show what the context was with regard to that point on pedophilia. But I accept Mr. Minister's reply to my second question. Thank you, Mr. Speaker.
Any other questions, clarifications? Ms. Hazelpour?
Thank you, Mr. Speaker. I wish to respond to Minister Massago's comment earlier on PSP's position. I wish to clarify that our position on wanting the definition of marriage to be determined via a national referendum instead of Parliament is not a convenient way to avoid difficult decisions. A case in point would be the fact that we do have a position on 377A, which is also a difficult one. We are aware of the government's position on what the criteria for holding a referendum is, just that we have a slightly different view on what are the issues that should go for a referendum. In this particular case, on the issue of the definition of marriage, we feel that this is an issue that is important to many Singaporeans, and there is a high level of interest from the public to have a say in this matter. And since it is an area that does not require any specialized knowledge, which makes it unsuitable for participation from members of the public, we feel that, and actually marriage, as many members have pointed out, is a matter of social norm. We feel that this is an area that is suitable for the public to participate. Thank you.
I thank the member for the clarification, but I think the most important question is not the referendum, is what is PSP's position on the constitutional amendment? Are they for or against? And therefore, when the referendum, if held, is it for, are they for or against?
Okay, as far as the vote for the constitutional amendment is concerned, we will be voting no because of what I explained earlier, that we would like the definition of marriage to be via referendum rather than by through Parliament.
Finally, that's come out in the open. So we know that they're going to support the repeal of 73A. 377A, sorry. Repeal of 377A, but they will not support that the constitution, the amendment to the constitution be made, which means that while now there will be no further challenges to 377A because it doesn't exist, there will now be new challenges that will be put up in court on constitutional grounds that other institutions like marriage and families, important to many Singaporeans, will stand before the court, and then we are back to square one again. We have to reactively again come to make a decision or wait for the court to make that decision.
We will support a constitutional amendment if it says that the definition of marriage is to be determined via national referendum.
Then we'll wait for the train to crash on us.
Mr. William.
Thank you, Speaker. I wish to make 4 points, if I may. 3 are clarifications for the Home Affairs Minister, and 1 is a clarification on my position on the Constitution Amendment Bill. So let me go to the clarifications for Minister for Home Affairs. Okay, yesterday during his call it second reading speech, he cited many court challenges to the constitutionality of Section 377A. We are all aware of them. But I don't believe any of the ministers cited any court challenges to the heterosexual definition of marriage. So I'd like to ask the government whether there has been any court challenge to the heterosexual definition of marriage. And to that extent, would he not agree with me that his analogy of the oncoming train applies to 377A but does not quite apply to the heterosexual definition of marriage? Second clarification, earlier he mentioned that the government does not believe that their policies violate the Constitution. So I'd like to ask him, without Article 156 being enacted, is the government not confident that it can convince a court that marriage based on a heterosexual definition is based on reasonable criteria, it serves the purpose of promoting procreation within a family unit under AMLA, under Women's Charter, and therefore, the government is on much stronger footing on this, the constitutionality of the heterosexual definition of marriage compared to 377A. That's my belief anyway. The third clarification is I'd like to ask him to confirm that he accepts that the courts have a constitutional role to ensure that Parliament's laws and government actions do conform with the Constitution. I'd like his confirmation on that. And lastly, sir, my clarification. For the Constitutional Amendment Bill, I did say that I am not opposing the bill, but I'm abstaining. And the reason I'm abstaining is that I am concerned about the role of the courts as having judicial oversight over the legality of government actions and Parliament. I'm concerned that that should be protected. So I, for one, value it, and that is why I'm abstaining.
Clarify or repeat the third clarification, please. I didn't quite get that. The third clarification.
The third clarification is I'd like our Minister to confirm whether he accepts that the courts have a constitutional role to ensure that government actions as well as Parliament's laws do conform to the Constitution.
Yes. Okay, so 3 questions. One, whether I agree that while there is a more immediate risk on 377A, that those concerns don't quite apply to the definition, current definition of marriage. No, I don't quite agree. I think what we can see and what we need to take reference from is what has happened elsewhere. So we agree that there is a significant risk to 377A. I think there all of us agree. What is the government's concern about the current definition of marriage? You look at what's happened in India. The courts first said that their version of their 377 was not unconstitutional, and then within a few years, they said, well, it is unconstitutional. And now, earlier this year, they have said the definition of marriage should be broader than a pure heterosexual marriage. It's a similar system and similar broad common law principles. One can say and one can discern that there are different approaches that the Singapore courts take vis-a-vis the Indian courts. But I think if you were to look at it as a lawyer, legal analysis, and particularly if you are charged with a heavy responsibility to make sure that Singapore is looked after properly and that you care for Singapore and that your concern is for the well-being of Singaporeans, then you will not take these risks. You will think them through, whether it is immediate or perhaps it is in the midterm. If you think that there is a risk, then our duty is to go out there, explain the risks, and then say how we would seek to put the laws in place to protect society, protect marriage, protect the institution of marriage and the structure of marriage, so that our society, successful as it has been, can continue to be successful, and so that the fundamental values of Singaporeans can be protected. It's not a game. You don't take chances. You don't take fine legal analysis. Fine legal analysis is necessary to identify whether there is a risk. Once you identify there is a risk, you then don't go and take chances. So if one were to ask, is the risk to the heterosexual definition of marriage less than the risk to Section 377A? The answer is yes. But that does not lead to, well, we don't have to do anything about it. If there is a risk to something as fundamental as marriage, you act, or at least this government acts. Now, second, do I not believe that the government can convince the court that marriage, that providing for a heterosexual definition of marriage, we can tell the court it's reasonable to say it should be between a man and a woman? Well, you've seen the arguments elsewhere. You've seen the social policy changes in the United Kingdom from which many of our laws come. Of course, there the laws have been changed through Parliament, but there are many countries where the laws have been changed through the courts. And I, for one, while I believe that our courts have always taken the approach, there are three great branches of the state, as I said yesterday: the courts, the judiciary, Parliament, and the executive. And the system has worked well because each has respected the sphere of the other, and our judiciary is independent. If I were asked, I would say there is a reasonably good likelihood that we will be able to persuade the court today that there is a basis for making a distinction between same-sex marriages and heterosexual marriages, and that the current definition of marriage in the Women's Charter should be maintained. But if I were asked a different question, is there a risk that it could be struck out? I think it would be either a stupid lawyer or a foolish lawyer who will say there is no risk. And if you accept that there is a risk, then what do you do? what do we do as parliamentarians? I think the answer is clear. Third, do I accept that the courts have a constitutional role? Of course I accept that. But I think if the question goes towards why do we then say that the courts should not look at the definition of marriage, I think I've given a very extensive answer. What should count as marriage should be decided here. The courts can only make binary decisions. We should discuss it, we should decide it, and we should take into account what society is ready for and what society needs and what strengthens society. And even if we take a view which is different from the majority view, then it's our duty to go and convince society as to why we are taking that view. We can do all of those things. The courts cannot do those things. That is why we have decided there is this risk that the definition of marriage could be challenged. And we have decided that's a matter for Parliament. We are not providing for a supermajority, so any elected government, by a simple majority, can decide on what a marriage ought to be like. That is democracy. That's how democracy ought to work. And no court can do what we did yesterday and today, which is to consider repealing 377A, but at the same time, strengthening the institution of marriage and explaining the reasons, having it fully discussed, going out to the public and explaining. That is what's necessary, and that we believe that a future discussion would require these sorts of discussions, and it may require changes to more than one piece of legislation. How does the court do that? They will decide on the question presented to them and strike out if they think it should be struck out. Where does that leave society? So this is not a case of, oh, are we avoiding the supervisory jurisdiction of the courts? It's been explained. And I believe majority of Singaporeans, the overwhelming majority of Singaporeans, support us on this constitutional amendment.
The question is that the bill be now read a second time. Pursuant to Article 5(2) of the Constitution, a vote is taken to ascertain that the second reading of the bill is supported by the votes of not less than 2/3 of the total number of elected and non-constituency MPs, which is 63 members. Clerk, ring the division bells. Sergeant-at-Arms, lock the doors. I know that there are members seated in the speakers gallery. For members seated there, the clerk will call your name to indicate your vote. Members seated within the bar of the House will vote electronically. They are reminded to be seated at your designated seats. Clerk will first call the names of members seated in the speakers gallery to indicate their votes. These members are to verbally state their vote indication when the names are called by the clerk in alphabetical order. The question is that the bill be now read a second time. The clerk will now proceed to record the votes.
Mr. Louis Chua.
Aye.
Ms. He Ting Ru.
Abstain.
Ms. Sylvia Lim.
Abstain.
The manual voting is now completed. We will now proceed with the electronic voting for members seated within the bar of the House. These members should only start to vote when the voting buttons on their armrests start to blink. Take a vote. You may now begin to vote. May I remind members to depress their vote button firmly in order to register your vote in the system. Members seated within the bar of the House are advised to check that their names are registered according to their vote indication when the voting results are shown on the display screens. These results do not include the votes taken manually from the members seated in the speakers gallery, and the final results are subject to the addition of these votes. Before I proceed to declare the results of the vote, are there any members who wish to claim that his or her vote has not been recorded correctly? I'll proceed to declare the voting results now. There are 85 ayes, 2 noes, and 2 abstentions. The second reading of the bill has been carried by votes of not less than 2/3 of the total number of elected and non-constituency MPs.
Constitution of the Republic of Singapore, Amendment Number 3 Bill.
Committee Sage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. question is that clauses 1 to 2 stand part of the bill. As many as are of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Social and Family Development.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendments.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. Pursuant to Article 5.2 of the Constitution, a vote is taken to ascertain that the third reading of the bill is supported by the votes of not less than 2/3 of the total number of elected and non-constituency MPs, which is 63 members. Clerk, ring the division bells. Sergeant at Arms, lock the doors. The question is that the bill be now read a third time. The clerk will now proceed to record the votes of members in the Speaker's gallery.
Mr. Louis Chua.
Yes. Yes.
Ms. He Ting Ru.
Abstain.
Ms. Sylvia Lim.
Abstain.
The manual voting is completed. We will now proceed with the electronic voting for members seated within the bar of the House. Again, members should only start to vote when the voting buttons on the armrests start to blink. Take a vote. Once again, do remember to depress the vote button firmly to register your vote in the system. Members are advised to check that the names are registered according to their vote indication when the voting results are shown on the display screens. These results do not include the votes taken manually from the members seated in the Speaker's gallery, and the final results are subject to the addition of these votes. Do I need to say anything? Yeah, I forgot to vote. So manually included it. So before I proceed to declare the results of the vote, are there any members, apart from myself, who wish to claim that his or her vote has not been recorded correctly? We'll proceed to declare the voting results now. There are 85 ayes, 2 noes, and 2 abstentions. The third reading of the bill has been carried by the votes of not less than 2/3 of the total number of elected and non-constituency MPs.
Constitution of the Republic of Singapore Amendment Number 3 Bill. Item 2, Penal Code Amendment Bill, second reading.
Minister for Home Affairs.
Mr. Speaker, sir, I beg to move that the bill be now read a second time, and I suppose I should read out yesterday's speech. Sir, the Penal Code Amendment Bill will repeal Section 377A of the Penal Code. As members know, it criminalizes acts of gross indecency between males, whether in public or private. And this bill is linked to the previous bill in our order paper, the Constitution of the Republic of Singapore Amendment Bill, Amendment Number 3 Bill. In the debate we have just had on the Constitution Amendment Bill, I have explained the reasons for repealing 377A. Members have already raised their questions and expressed their views on both bills during the earlier debate, although they are still welcome to do so now if there are any additional questions or views. And before I sit down, sir, I've gotten the transcript of what Mr. Singh said yesterday, and I think I should read it and put it on record. He said, and I quote, "The People's Action Party has announced that it is not lifting the whip for this debate. Given the very public opinion on the impending repeal of Section 377A, there is a risk that the democratic value of Parliament could be diluted if the views of Singaporeans on this subject are not adequately ventilated in the House." That's the point I was responding to, and that's simply untrue. It's inaccurate, and it does not do this House any credit, because you are entitled to ventilate your views. We have always been ventilating our views, and it should not be thought of in public that if the whip is imposed, you cannot ventilate your views. Mr. Singh also explained that the Workers' Party will be lifting the whip, and he wasn't talking about some years ago, he was talking about this debate. If needed, I can read out other paragraphs, but I think I'm just reading out what he said. Thank you, sir.
Mr. Singh.
Mr. Speaker, that is an accurate rendition of what I said. But immediately after that also, I said not lifting the whip would deny Workers' Party MPs not in favor of the repeal of 377A the opportunity to vote freely, and in doing so to also represent Singaporeans who see this issue as a matter of deep religious belief and conscience. But the Minister is not wrong when he says, even though the whip is not lifted, it's entirely true that members can speak freely. I don't dispute that, Minister.
Thank you, Mr. Speaker. So I thank the leader for that clarification. And so I stand by everything I've said earlier, which is based on an accurate understanding of what Mr. Singh had said. And so I think I'm not seeing many people wanting to speak, but we will.
Any more clarifications, comments? No?
I beg to move, sir.
The question is that the bill be now read a second time. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it.
Mr. Speaker, may I call for a division, please?
Will honourable members who support the division please rise in their places? Clerk, ring the division bells. Sergeant at Arms, lock the doors. Question is that the bill be now read a second time. Whip, you have claimed a division. Would you like to proceed with the division?
Yes, please, Mr. Speaker.
Clerk, proceed with the division. I note that there are members seated in the Speaker's Gallery. For members seated there, the clerk will call your name to indicate your vote. Members seated within the bar of the House will again vote electronically. You're reminded to be seated at designated seats and should only start to vote when the voting buttons on the armrest start to blink. The clerk will first call the names of members seated in the Speaker's Gallery to indicate their votes. These members are to verbally state their vote indication when their names are called by the clerk in alphabetical order. The clerk will now proceed to record the votes.
Mr. Louis Chua.
Yes.
Ms. He Ting Ru.
Yes.
Ms. Sylvia Lim.
Yes.
The manual voting is completed. We will now proceed with the electronic voting for members seated within the bar of the House. These members should only start to vote when the voting buttons on the armrest start to blink. Members seated within the bar of the House may begin to vote. Members seated within the bar of the House are advised to check that their names are registered according to their vote indication when the electronic voting results are shown on the display screens. These results do not include the votes taken manually from the members seated in the Speaker's Gallery, and the final results are subject to the addition of these votes. Ms. Semen. Before I proceed to declare the results of the vote, are there any members who wish to claim that his or her vote has not been recorded correctly? We'll proceed to declare the voting results now. There are 93 ayes, 3 noes, and 0 abstentions. The ayes have it.
Penal Code Amendment Bill.
Committee Sage, what day?
Now, so I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into committee on the bill. As many as of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. Whip.
Mr. Speaker, may I call for division, please?
Shall I call it during the third reading? I think the ayes have it. Mr. Dennis Tan.
May I have my dissent be recorded together with the others whose dissent, for their dissent to be recorded too?
Will it do that during the third reading instead? The ayes, let's try again. Question is that Parliament will immediately resolve itself into a committee on the bill. As many as of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 4 send part of the bill. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The schedule. The question is that the schedule stands part of the bill. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Home Affairs.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as of the opinion say aye. Aye. To the contrary, say no. Whip.
Mr. Speaker, may I have a call for division, please?
Let me gather the voices. I think the ayes have it. Clerks, ring the bell. Sergeant at Arms, lock the doors. Question is that the bill be now read a third time. Whip, would you like to proceed with the division?
Yes, please, Mr. Speaker.
Clerk, proceed with the division. I know that there are members seated in the Speaker's gallery. For members seated there, the clerk will call your name to indicate your vote. Members seated within the bar of the House will vote electronically. They are reminded to be seated at their designated seats and should only start to vote when the voting buttons on the armrest start to blink. The clerk will first call names of members seated in the Speaker's gallery to indicate their votes. These members are to verbally state their vote indication when the names are called by the clerk in alphabetical order. The clerk will now proceed to record the votes.
Mr. Louis Chua.
Yes.
Aye. Ms. He Ting Ru.
Yes.
Yes. Aye. Ms. Sylvia Lim.
Yes.
Aye.
The manual voting is completed. We will now proceed with the electronic voting for members seated within the bar of the House. These members should only start to vote when the voting buttons on the armrest start to blink. Please proceed to vote. Members are advised to check the names are registered according to the vote indications when the electronic voting results are shown on the display screens. And again, these results do not include the votes taken manually from the members seated in the Speaker's gallery. And the final results will be subject to the addition of these votes. Before I proceed to declare the results of the vote, are there any members who wish to claim that his or her vote has not been recorded correctly? Please.
Speaker, I'm registering my vote as yes. Sorry, it comes up. Apologies.
It is registered as yes. Is that correct? I will now proceed to declare the voting results. There are 93 ayes, 3 noes, and 0 abstentions. The ayes have it.
Penal Code Amendment Bill. Item 3, Post-Appeal Applications in Capital Cases Bill, second reading.
Minister for Law.
Mr. Speaker, sir, on behalf of the Minister for Law, I beg to move that the bill be now read a second time. The government has made important changes to the criminal justice system in recent years towards a more progressive, balanced, and modern criminal justice system that delivers just outcomes and protects society from crime. What we are putting forward before you today are measures to provide a process for post-appeal applications in capital cases. Post-appeal applications in capital cases are applications that are filed by a prisoner awaiting capital punishment, or PACP, after all avenues of appeal have been exhausted. Normally, given that all appeals have been exhausted, there will be no further applications possible. These amendments provide a process for making such applications. Let me first explain the context of such post-appeal applications. Today, capital cases are governed by a rigorous process with multiple safeguards. First, all persons facing capital charges are offered free legal representation under the Legal Assistance Scheme for capital offences at trial